warm welcome to everyone in this joint event organized by the UCL, Center for Law, Economics and Society, and the Inclusive Competition Forum. A few words first about the initiative. One might ask why yet another forum or conference on the reform of Article 102 in Brussels, following the quite important number of conferences. I counted actually 3 already last month on exactly the same topic. And the answer is maybe because, and this is also one of the reasons why we started the Inclusive Competition Forum initiative. These conferences are, of course, very useful for the debate, but they tend to focus on the usual technical, mainly, discussions we have in the competition law bubble. Usually, they bring the same players, officials, academics, practitioners representing mostly big corporations in pending investigations, and tend to result to somehow discussions that emphasize mostly, I would say, the concerns of the bar and their clients, and then for the need of a more economic approach or a less economic approach, which to a certain extent is an interesting issue, but not really the thing that we are very much interested today to focus on. Of course, the Commission has done important efforts in recent years to make competition law relevant for people, make markets work for people, and there has been a quite important investment from the Commission. But the people who usually hear in these debates are the same people that have been running competition law for the last 30 years, and I include myself also in that. And at the same time, we observe that there is increasing interest from the civil society, which embraces a little bit more this competition law debate and this competition agenda, and puts forward different proposals. So we had, I think, yesterday, this anti-monopoly manifesto that was published by a number of non-profits and the NGOs interested in competition law and policy. And therefore, we see also in the media more and more discussions about competition law and policy. I think probably the price hikes, the inflationary times we're living in has attracted more attention on the role of competition. And when actually we look to these debates in the media, but also when we read the manifesto from these civil society organizations, we see that there is emphasis not on the same type of issues that we discuss in the competition circles. There is, reference to concentration of economic power, the role of competition to protect democracy, and of course, these somehow push us to think about maybe, we have to link again competition law to the broader policy discussions that occur outside our competition law and economics bubble. I don't think we can stay indifferent to such initiatives and to such policy discussions, in particular if we want to, do competition law for the people and to make competition law somehow help markets to work better for people. So from our perspective, I mean, this is a really bit what motivated us as well to start the Inclusive Competition Forum a couple of years ago. It was this idea of linking a little bit the various stakeholders representing the civil society from one side, the academics working in the field, coming from very different traditions, and of course, policymakers. And the idea is with the organization of a number of debates and conferences like this one today, to open up discussion to stakeholders that haven't really been participating to that discussion, at least until now, I think. I think the last couple of years probably with this initiative of the European Commission to make markets work for people. And at the same time, I think to bring in a little bit in contact the stakeholders with a number of academics working in the field and producing work that could possibly make some of the arguments that they're making a little bit more attractive to policymakers, so that they can walk the walk and talk the talk, actually put it that way, and that their contributions are not only taking a critical perspective is absolutely needed, but also lead to concrete proposals for concepts that can be operationalized and used in competition law enforcement, because I think this is how you can achieve change. It's not just about criticism about what is going with the status quo, but also about what to replace and what actually to bring in this debate. And I think we need, and I talk here also with my experience as a former competition authority official, we need to have these new methodologies, these new conceptual frameworks, and for that to work so as to be able to replace what we have, with something that we know works. So what I would like, we organize a little bit this session today in two parts. So the first part is going to be a little bit more technical debate on Article 102, but again, we're not just going to focus on the exclusionary abuses angle, although I know that this is something that the Commission has been mostly focusing on, because I think that all these questions about the broader normative values that we have in terms of how we can conceive, we conceive the concept of abuse, how we can interpret this provision that has stayed the same since the Treaty of Rome, but has been interpreted in very different ways. I think we need to open up a little bit of debate about, more generally, also exploitative abuses, as well as the boundaries, let's say, of the scopes of Article 102 concerning different types of conduct. And to link that debate to the policy debate, and this is a little bit the second part, which will be organized in two sessions. So the first one will bring in policymakers to somehow provide us their perspective on the broader normative values that have inspired their work in terms of how they can start operationalizing the law with different concepts. And secondly, stakeholders that have a lot of things, I think, to say about the way they conceive competition law and policy and how this might possibly be implemented in the context of Article 102. So we are programming also a number of other discussions which will take place in Brussels, always in cooperation with a number of our university partners. So this time is UCL, next time probably it's going to be a different university in collaboration with the Inclusive Competition Forum. And we are going to touch upon issues concerning lobbying in competition law and policy, the issue of industrial policy and competition law. So stay tuned. I think we're going to have quite a few other interesting sessions. So I would like first to thank my colleagues for having accepted to contribute here to the debate, and I'm passing the floor to Julian, who's going to chair the first session.
Yes, thank you, Ioannis, and I'm super happy that we are still on time. That is a good sign. We're actually ahead of time. Maybe we are also ahead of time in terms of the discussion. Actually, our panel has the term zeitgeist, however you want to pronounce it. And so first we're going to start with Inge, who is the Director of Policy and Strategy at DG Comp, and she will give us an outline of the current thinking about the reforms about Article 102. And then we have a number of distinguished academics joining the debate. Denny from UCL, she will talk about the role of the as efficient competitor test or principle in 102. And then Anna from Utrecht, she's going to talk about the power of corporations and a bit on fairness. Then we switch over to Simon from the CAT and in Oxford, and he will, as we might be surprised to hear, talk about sustainability and 102. Then we have Florian, who is joining us from Hamburg, from the Helmut Schmidt University, who is going to focus a bit on the national application of 102 and national law and the interaction between national law and EU law in that area. And finally, we have Stavros, who is currently at the University of Glasgow, who is talking about the goals of competition law and in particular with regard to 102. And what we're going to do is we're going to have kind of a first round of short presentations, and then we're going to open the floor here for some comments and then open the floor there for some more comments. But now, without further ado, over to you, Inge.
Thank you very much. Thank you, first of all, to Yannis for inviting me here, and to Julian for the introduction. I'm really keen not just to introduce the topic of 102 to you from the Commission's perspective, but also to listen to what my co-panelists have to say and to engage with you. Because this is indeed, as Johannes said in his introduction, a very interesting juncture for us in competition policy terms. First of all, because of the broad question of what's the role of competition policy within broader societal contexts and debates. But secondly, more technically also when it comes to Article 102 of the treaty, the provision that prohibits abuses of companies holding dominant positions. Because we are working for the first time, I would say, in the history of EU competition law on guidelines in this field. These guidelines, to immediately already touch upon one issue on which no doubt we'll discuss, focus on exclusionary conduct. That is not to say that we don't think that the enforcement of the enforcement against exploitative abuses is not important. As a matter of fact, we've quite recently been doing a couple of exploitative cases, including very recently the decision against Apple in the Spotify case, which was a non-price exploitative case. And we recently launched also a statement of objections against Facebook on the marketplace case, which is also an exploitative case. But coming back to the guidelines, why guidelines and why do they focus on exploitative abuses? I think to understand that we need to go back in history a little bit to the early years of this millennium, when there was a quite intense discussion in academia, but also in the enforcement community, about the so-called more economic approach, as opposed to a more legalistic or form-based approach when it comes to applying Article 102, and in particular in the context of exclusionary debates. The debate was not limited to 102. In fact, it started in the context of Article 101, where we reached the conclusion that unless an agreement or a concerted practice has the object to restrict competition, you actually need to look into its effects, into the concrete circumstances of every case, because otherwise you may reach the wrong conclusions from a public policy perspective, and you may actually over-enforce and hinder what is pro-competitive agreements. Think about information exchange, whether that is in a vertical supply context, for example. It's often part of very pro-competitive behavior to have information exchange there. At the same time, it can be very anti-competitive. Or take joint purchasing, an issue which is not irrelevant in the context of sustainability. We might come back to that. Depending on the circumstances, it can be very pro-competitive or it can be very anti-competitive. Also, when it came to Article 102, there was this growing awareness that was no doubt influenced by changing insights in economic science, but no doubt also influenced by a debate in the US that was running ahead of developments in the EU. A debate and an awareness that actually integrating a degree of economic analysis into our assessment of abuse cases could help us to get it right. Very much, I think, an awareness also, we say this for dominant companies, that with special power comes special responsibility, but we apply that also to ourselves as enforcers. We also have a lot of power, and that too comes with a special responsibility to make an effort to get it right. And I think that led us back in 2008 to adopt then a guidance paper in which we introduced some of that more economic approach into our reasoning, and we indicated to our stakeholders, to the world outside, how we would envisage to apply it in selecting cases for enforcement, what would be the cases that we would be doing and which cases would we not be pursuing, and how we would envisage to enforce it. But since 2008, a lot of water has passed under the bridge. We've done in the first place a whole lot of exclusionary abuse cases in the digital sector, but also in very traditional sectors. Not just us, but also national competition authorities, although there I must say that it is to quite some diverging degrees. Some of them have not enforced one or too much, others have been very active in this field just like us. Courts have also been active, including national courts, and we see that through a whole body of case law that comes not only from appeals against our decisions, but that come also through preliminary rulings. And there has been more academic debate and more public debate on these issues. So collectively, we just have more knowledge on how to enforce Article 102 to exclusionary conducts. On substance, in some parts, the Court of Justice told us that we got it wrong in our guidance paper. For example, on refusal to supply, the court told us that actually we were too strict on ourselves in terms of enforcement. In other parts, the court further clarified things, like on that it's not enough to show purely hypothetical effects, but that on the other hand, we don't need to show actual effects either, that we are talking about potential effects. And in other areas, we just acquired, by doing the cases and by looking at fellow agencies do their own cases, we just got more and better insights in what type of conduct, under what circumstances, is highly likely to be problematic, and conversely, what conduct and under what circumstances is very unlikely to be problematic. Third observation about the water that passed under the bridge since 2008 is that our procedures have definitely become much more complex and lengthy because of the integration of economic assessment in the cases. And we have seen, that is very much from our perspective as enforcement agency, that defense companies, the defense lawyers, have made extensive use of bringing economic evidence and economic arguments. A lot of that, no doubt, for good reasons, but sometimes also overdoing it to the point where you question whether the strategy was not rather about throwing sand into the engine of enforcement, rather than really looking at a case from all angles. So the cost of administrating Article 102 to exclusionary cases has definitely gone up tremendously, which raised the question about effectiveness. Effectiveness in terms of, are we enforcing enough? Are there not too many problematic cases left unaddressed? And can we enforce quickly enough, in particular against the background also of digitization, where markets tend to tip quite quickly. If then your procedures are too long and too slow, then as an enforcer, you do too little and too late. So these three elements, the acquired collective wisdom from an enforcement perspective, what the courts have told us, and then the importance of making sure that Article 102 remains an effective and an efficient instrument, have led us to conclude that the time was right to launch the process, and that we started it with a call for input in drafting actual guidelines. But that also explains, with this background of the more economic approach, why, and with the guidance paper, why also the guidelines will be focused on exclusionary conducts. Now we are in an early phase. We are listening a lot, we are reading a lot, in particular the contributions that we've received, and we are drafting. So there's not much that I can say at this stage, but nevertheless I wanted to shed some light on our thinking. In the first place, we think it is absolutely important to be explicit about how we see the objective of Article 102. Why is it so important to act against exclusionary conduct in this particular juncture, including in the context that we will be discussing later about sustainability, for example. For us, the consumer welfare standard is well known. It's clear that in the EU, the focus has always been on the competitive process and safeguarding the competitive structure in market, and that competitive structures lead to positive outcomes for consumers. I think that's not just an ideological vision which is enshrined in the treaty. It has also proven its success. But more and more also at this juncture, including against the background of sustainability, You get the debate again about static competition versus dynamic competition, short-term effects on prices versus longer-term dynamics, and the importance of innovation as one of the major solutions that we will need to promote also in order to address sustainability challenges and climate challenges. So that is very much enshrined also in our thinking, and why we believe that addressing exclusionary conduct in an effective and in an efficient manner is important to keep the markets open and competitive, to keep the competitive dynamics and the push for innovation going, including against the background of tackling a number of societal challenges that we face. Second part that we want to address is actually, what is the standard of intervention? What is it that a dominant company is allowed to do in terms of its conduct? What is its principal freedom of undertaking? What does it mean, and where are the boundaries that come from Article 102 when it comes to exclusionary conduct? The case law of the court has said consistently and very clearly that a dominant company, that being dominant is not an abuse in itself, but that the dominant company has a special responsibility to, through its conduct, not to deteriorate or weaken further the competition which is left in the market, which by the presence of it as dominant company is already weakened. And the court has also been shedding some lights of two elements in that assessment, one of it relating to what is competition on the merit and what is competition of the merit, and how does that play a role in the assessment of when conduct becomes abusive. And the other element is to do precisely that assessment of effects. How should that be assessed by an enforcement agency or by a company when it's trying to self-assess? And thirdly, what we want to do, and that will be, I think, the gist of the guidelines, is to make it concrete on what that means exactly. How can you enforce the effects-based approach? How do we intend to enforce it, and how can companies self-assess this for specific types of conduct? Because the court has on some forms of conduct given us a quite precise test. Predatory pricing is, I think, an example which springs to mind, but also for other types of conduct, it has become more and more explicit on the circumstances in which that type of conduct is problematic and is not problematic. Rebates, for example. Rebates are not per se problematic, but they can be very problematic, and we can say a lot on how, when they are linked to exclusivity parameters, they are highly likely to be problematic. So our idea is to systematize all of that and to try to spell it out per type of conduct, like how we would intend to enforce the rules. And again, what we want to do in that context as well is to differentiate a bit, to say like, okay, the evidentiary burden that we need to meet as an enforcement agency, is it logical that it should be the same no matter what type of conduct we are talking about, or can we draw lessons from the collective know-how that we have to try to put things together in some boxes and to say, well, maybe here the evidentiary burden is not the same as for other conducts, but because we know that there is a high likelihood of this sort of effects or not. Compare it a bit to a person jumping from the 10th stock of a building. Do you need these econometrics to decide that there is a risk that the person may be dead? So that's I think the point where we want to start to make some differentiation. And that is not to say that the specific circumstances of a case cannot and should not play a role. It should always be possible for a defendant to argue, for example, that my building stands in the middle of the ocean and therefore maybe the risk of dying is lower, or that the person was jumping because the building was on fire. So there should be room for rebuttals, there should be room for defenses being brought. But we think that the starting point, or that as a starting point one can reasonably bring forward the position that the evidentiary burden should not be the same for all categories of conduct. That brings me to 30 seconds of next steps. So our aim is to publish, of course, a draft text of the guidelines for comments, as we always do in competition law instruments. And that publication, we right now foresee it around the summer. Timing may always change due to circumstances, but currently we think we are on track to keep that, that timing. The publication of the draft text will, of course, launch a second phase of debate, and a very intense debate where we can also be more specific on points. And that will then take us quite naturally to the start of the new mandate of the new Commission. And it will certainly be for the new Commission to take the final decision on the adoption of the guidelines.
Great. Thanks, Inge. That was a lovely kind of summary, bringing it all together, setting it all out, and then we can delve into a couple more detailed questions, and I'll pass over to Danny in that regard first.
Thank you very much for this kind invitation and excellent initiative, Johannes and UCL. Now, I will follow up with a bit more technical, but then hopefully in the course of the discussion, we can expand on some of the things Inge mentioned in her presentation. I think the Commission, my interpretation of the Commission and its amendments to the guidelines paper is seeking to weaken both the principle and to set and extend the test, which has been the as efficient competitor test I'm referring to, which has been the cornerstone of analysis in mostly price-based conduct in the 2009 guidelines. And there are three key points I would like to raise. The first point is that any discussion on the reform, including the role of the principle and the test, should be understood, in my view, as a reaction on the part of the Commission to the effects-based approach. EU courts in Intel, Qualcomm, Google Android started to embrace a more economic approach, maybe at the time of its decline. Commission is reacting as the effects-based approach raises its enforcement cost, sets the bar for intervention so high that enforcement becomes burdensome, and it reacts with amending the guidelines. Is it too little, too late, given that the principle may have already been firmly embedded in the case law? This is something I wish to explore. The second point I would like to raise is that although the as efficient competitor principle or standard remains in the wording of the court, a fundamental aspect in Article 102, the relevance and application of the test in price-based exclusionary conduct has diminished over the years. And we have the final pronouncement of the court in Unilever, paragraph 58, explicitly stating that authorities cannot be under a legal obligation to use the as efficient competitor test in order to find that a practice is abusive. And the final point I would like to raise, and I was inspired by George's point in a conference we're together in Bruges. Maybe we're reading too much in the as efficient competitor principle and standard. Is this used as a firmly embedded principle in the court's case law, or as a rhetoric device? And that is something to be explored. Many commentators, including myself, see this as a principle firmly embedded in the case law, but that is a useful here challenge. Now, the pronouncement of the principle and the standard, or standard and the test, as a red line in the Commission guidance paper appears in paragraph 23. The Commission, with a view to preventing anti-competitive foreclosure, says back in 2009, will normally only intervene when the conduct concerned has already been or is capable of hampering competition from competitors which are considered to be as efficient as the dominant undertaking. And then lays down the test. Now, in the case law of the courts, we find the principles, starting with post-Denmark, competition 1, because Denmark 1, competition on the merits may by definition lead to the departure from the market or the marginalization of competitors that are less efficient. And this is repeated in Intel, in Anil, and in Google Shopping. So the court is here trying to say it is not the objective of Article 102 to protect inefficient competitors offering higher prices, worse products, and less innovation. And this principle and standard, or standard, is significant because it goes hand in hand with embracing an economic effects-based approach. The court has confirmed that conduct cannot be found to constitute an abuse without an assessment of its exclusionary effects on competition coming from equally efficient competitors of the dominant undertaking. Now, while the principle seems to be applicable across the board in price and non-price based conduct, the test seems to be confined to pricing abuses only. That is a direct consequence of this classification we have in EU competition law between price and non-price abuses. The principle is broader than the test, and that can be problematic in an effort to reform. The court in LL said, referring to the test, that loyalty rebates, low pricing practices in the form of selective or predatory pricing, and in margin squeeze practices, this is clear that as a general rule should be assessed by using the as efficient competitor test. So that is the latest here pronouncement we have. Now, are we reading too much into the as efficient competitor principle? Is it a principle of EU competition law or a rhetoric device? Does it mean that only conduct that would exclude as efficient competitor is abusive? Wouldn't this be a very narrow perspective? Does this reflect the values and the variety of goals that are enshrined in both the treaties and the case law that competition law should promote? Even if one adopts an economic efficiency perspective on consumer welfare, excluding the as efficient competitor may not always be a good proxy for consumer harm. Economic efficiency as well as consumer welfare in many circumstances can benefit also from the existence of less efficient competitors, either in a static sense, as Inge referred to, by the restraint that these inefficient rivals may exert on the dominant firm's pricing, or in a more dynamic sense, when the new rivals have the potential but need time to reach efficiency. They're not yet as efficient. Now, in situations of overwhelming dominance, consumers will benefit from entry, even if the entrant is not as efficient as the incumbent, right? And that circumstances involve, I think, a departure from both the principle and the test, and that is recognized in post-Denmark 2, where the market had high barriers to entry. Now, the protection of not yet as efficient competitors has been there in the case law. That's why I think we shouldn't be reading too much in the as efficient competitor principle as laid down in LL and mostly in NL. The revised now guidelines recognize that in certain unspecified yet circumstances, companies that are not yet as efficient may also warrant protection from exclusionary behavior by dominant undertakings. It refers to markets where barriers to entry and expansion are significant and provides digital markets as an example. Is this, however, at odds with Intel, NL, and Google Shopping? Turning to the test, how will the Commission treat economic evidence in the form of an efficient competitor test already submitted by the parties in the context of an investigation? And finally, to conclude, I think this is a step, a sort of a rethinking the role of both the principle and the test is a step in the right direction in recognizing firmly the multiplicity of goals, but can the Commission set itself free from a self-imposed straitjacket of of a more economic approach, especially now that has been endorsed by the courts? That would be my question, and I'll stop here. Thank you.
That was excellent. That was 5 seconds early. Excellent timing. Thank you. So, after you basically looked a bit into the effects on the competitors, we are now moving back to maybe a bit more the company itself and the fundamentals of power and so on. So I'll pass over to you.
Thank you very much. Yes, so I would like to zoom out again from theories of harm and zoom in on one of the underlying concepts, which is power. And this may sound far-fetched, what I'm going to present, but then I find comfort in the fact that in 2009, 2010, when I started pleading for having sustainability as a relevant thing in an Article 101, Paragraph 3 assessment, that 15 years later, look where we are. So maybe in 15 years' time, the Commission will also embrace what I'm telling you now. So power is a relevant, as a focal point also for social contract theory, of course, the contract between governments and citizens, and also of the political constitution and of the economic constitution. Now, I have a research project funded by the European Research Council on power of big tech companies. And we focus on big tech companies, but increasingly also on other platformized fields, such as agriculture. And we are probably also going to look into pharma. And we ask, what kind of power is this? It seems to us like something novel, something new. And how can we understand it? How can we grasp it? And do we have the vocabulary even to talk with others about what we think this power is? And that is a step that goes before the step of identifying harms and even before the step of identifying competition law relevant harms. So that's why I'm talking about fundamentals. So we came up with a concept to grasp this corporate power, and the basic idea is as follows. There's different ways to exert corporate power. It can be used instrumentally. This is well known in competition law circles. It can be used to influence structures and institutions, a bit like the structure of the market. But it can also be used, well, towards institutions is already slightly different, and it can also be used discursively to change how we speak, what we talk about, to influence the narrative. So that's the first, different dimensions to power, and then this power does not just impact the market, but the economic domain much more broadly, including labor, for example, but also the social, the political, and the personal domains. Now, if you have that as a concept, we've given it a label. This is very important if you apply for research funding. You have to have a lovely label. I call it modern bigness. And my PhD students now have made us a whale logo, which we have hoodies now, which is wonderful. So modern bigness. And with such a wider concept, we can then identify, that's the second step, of course, different ways in which this power is wielded. We can talk about it, we can grasp it, and also map the different effects, positive effects and negative effects. And it goes way beyond market effects, but includes, for example, effects on politics and also on discourse in politics, discourse about politics, but also discourse in social spheres. So the next question, much more relevant for Inge, is which of these effects, also the effects that are outside the market domain and do not really directly instrumental, it's not a direct instrumental way of wielding power, are Article 102 harms. Competition relevant harms. And we think, and I only have 7 minutes, so this will be going way too much into details, that yes, some of these harms, in aggregate forms especially, can also be considered a competition law relevant harm if you move beyond the current boundaries of Article 102. That's a complex reasoning, but the essence is this is true because from the business models perspectives of these companies, there is no difference between a consumer and a citizen. There is no difference between the market domain and the non-market domain. It's all about the business model, and it all stems from corporate power. So it's not just blurred, this citizen, consumer, market and non-market, it's irrelevant from the business model. And I think that's an important point to grasp. Now, if that is correct, and I'm a scholar, so it's up for debate, but I think some of this at least is correct. Current competition law, but also the other regulatory frameworks, do not really deal with all of this, or deal with it in very siloed ways, and do not focus enough on the aggregate. So if you look at the other regulatory framework, it's not about the aggregate effects, and definitely do not focus on power structures per se. So I'm now at a point, this is always a sort of a difficult point as a scholar, that I think my research question that I proposed in this whole project is too small, because I think what we really have to do as a competition law community, is to start thinking much more directly about power itself. Power as more than market power, and then how to counter that power within the law, but also outside of the law. And then, of course, my research question becomes really, really big. But within competition law especially, also with the social contract theory, we should take power itself as a thing that we have to discuss whether it's good or bad. But too much power really is not too much power. It's not just power comes with great responsibility, but maybe sometimes power well, you have to do something about the power structures itself. And you hear me hesitating, because we've been doing this research project with 9 PhDs involved, and I can list them all, for 4.5 years. There's still half a year left, and this is the point where I'm like, yeah, I need to do another research project with a much bigger question. But that was mine. I think I have 5 minutes. See,
Yes, amazing.
Yeah.
Do you want to take some more time?
No.
Like, that's good, then we're going to use that for discussion later.
No, because there's going to be lots and lots of questions.
Yes. Good.
See? So I can do more question answering.
Excellent. Then we have more time.
Yes.
Simon, yes.
Perhaps I should start again in view of the recording. No, don't go on, right. Since then, much of the focus has been on Article 102. I think it's returning to Article 102. This conference reflects that. The conference we're organising with the OECD in December reflects that. And indeed, Inga's several references to sustainability in a 102 context. I don't think we'd have heard that a year ago. And indeed, my last paper was with Michel Miga, very much focused on that, a sustainable future. How can controlled and monopoly power play a part? A whole section of that was devoted to this topic. For me, there are two aspects to the sustainability and 102 abuse of dominance debate, what's been called the sword aspect and the shield aspect. And I want to say just a quick word about the latter aspect, what it's not. Sustainability is not, when we call it a shield, any sort of get-out-of-jail-free card. It's not a defence to an abuse. You can analyse it, as Suzanne Kingston did well, as an objective justification. That is to say, where a dominant company engages in proportionate behaviour to take environmental or climate change issues into account, which might otherwise be seen as an abuse, and there's no other less restrictive way of doing it, this can be seen as an objective justification for behaviour which is prima facie an abuse. But for me, even that goes too far. It may be the way the law develops. But this comes too close to being a defence argument and risks reversing the burden of proof. To my mind, it comes in at a much earlier stage. If, for example, you were to, it's part of the actual concept of an abuse, the normal idea of an abuse, what it is in law, what common sense, what language tells you it is. I'll give you an example. If I supply something to Yanis, who is an efficient producer, he uses my inputs in an energy efficient way and disposes of them responsibly. And I provide something else and I charge him a good price, a low price. And I supply Julian, who's a real rogue. He just doesn't use things efficiently at all. He dumps things any old where. And I choose to charge him a higher price to encourage good behaviour. That, to my mind, should not be seen as a constructive refusal to supply Julian or as discriminatory pricing. It is simply not an abuse. I am discriminating, but not in the sense of an abuse. And we should not discourage dominant companies from trying to do the right thing. Just as we criticise big companies because they have the power and the clout and they can do a lot of harm in society, they also have the economic clout to do good, and we should do everything we can not to discourage the best behaviour, and particularly the good intentions of many people within those companies. But I think the main focus has really been on the sword side. As this conference shows, Article 102 is a powerful and flexible tool. And we're not just talking about the theoretical categories of abuse aren't closed in the AstraZeneca case, although that is clearly true. We are seeing this more and more, the flexible use of Article 102, especially by national competition authorities. And I'm thinking of the cases involving the misuse of regulation and IP, but more recently, cases on misleading communication and disparagement of competitors, Teva, Vifor Pharma, Roxtex, Novartis, etc. And I see no reason in principle why this flexibility shouldn't be used to attack unfair, unsustainable practices as an abuse. We're seeing some of this. Sustainability is a factor in several cases brought by national competition authorities recently. I think of the Italians. And in the CAT, the court I sit on, we've been joined by Yanis now, we have our first abuse of dominance case in a private damages action brought against water companies for underreporting the pollution of rivers. I think the claims were some £800 million. I've written extensively about how the sustainability fits into the purpose of Article 102 and the language, and particularly about the concept and abuse. And I just refer you to prior works on that. I just want to give you two examples rather than talk theory. Two examples which I would suggest. One I first used was the unfair purchase prices which some buyers give to growers, say, of cocoa or coffee. Prices that don't cover the cost of production, prices that don't enable the suppliers to feed their family, and which often lead to considerable, to an expansion of unsustainable agrarian practices. People may say, well, how do you know what's an unfair price? Well, how do you know what's an excessive price? How do you know what's a predatory price? We, as competition authorities, as courts, we have developed rules there. I've recently enrolled a 160-page judgment on excessive pricing. So I know it is difficult. I know it can be done. Surely we can develop similar rules and guidelines in relation to unfairly low prices. And the other example, which some of you have heard me use here before, is if a dominant company, 80% market share, disposes of waste into landfill or into a river and saves 10 euros by doing that, compared to competitors who dispose of things responsibly, incurring that 10 euro cost. Now, I would see the behaviour of the dominant company as exploitative, but in deference to the Commission's focus on exclusionary abuses, I see that it clearly has an exclusionary effect in the marketplace there. The smaller companies being excluded by the unsustainable, abusive conduct of the dominant company. Now, of course, there has to be limits to this. We need to establish rules and procedures, but we do that in all areas of the law. We do this in the area of dominance, as we have for excessive pricing and predatory pricing, as I've just referred to. Should we limit this to, in my latter example, to practices of the dominant company which are illegal? That would be a clear rule. But then you could say, well, what about, shouldn't we just leave that to the authorities, other authorities, the regulatory authorities? So it will be easy, but it wouldn't be very useful because there's so many instances. The problem is that the relevant environmental laws, whatever they may be, are not being enforced. So it needs to cover practices which are not illegal, but there needs to be some limits. What are those? Well, there needs to be some effect on competition. That's clear. This is competition law. And I would suggest that one way one might develop it is to have the practice needs to be contrary to well-established legal commitments or international conventions or reports, such as the Paris Agreement, Climate Change Act, the IPCC reports. That's the approach in some of the climate change litigation. Think of the Uganda case. The Dutch competition authorities, and indeed I have, referred to illicit practices. That sort of area could be developed. And the final point I'd make here, emphasizing that this is not a panacea. We are talking about Article 102 as one tool amongst others, and this would be a complement, sometimes filling a gap, where other tools and policies are not being effective. There's no reason why, though, we should not use the powerful tool of Article 102 as a sword to attack unsustainable practices by a company where they're dominant.
Simon, thank you. You promised me to stick to 8 minutes, and you have managed to 7.5. Thanks a lot. So we are saving time, bits and bits. So I'll pass over to Florian now, and please go ahead.
Okay. All right, we have already heard from Inge and Denny, especially that at the beginning of this century and the millennium, DG Competition basically pushed itself and the courts to adopt an effects-based approach that has de facto emasculated Article 102. They haven't been as blunt as I am stating this, but I'm German, so I hope I'm forgiven. The policy brief indicates that the Commission now wants to take a more sensible approach. We could call it an even more economic approach, although the Commission still clings to the effects-based terminology. De facto, it seems to me that it seems to be moving back towards a perhaps slightly more sophisticated form-based approach than we used to have, but still a form-based approach. And I think they are right to go into this direction. So where can we see this? Well, they are talking about ensuring the contestability of markets, and they value the competitive process, etc. All that is the terminology that we used for the form-based approach. Now, again, I very much welcome this change in direction, but as Denny stated, only time will tell whether the court will also agree with this without getting whiplash after just having adopted more or less central tenets of the effects-based approach. Now, for the time being, Article 102 doesn't look like a good choice for timely interventions. We only have to think of Intel. I mean, you stated that sort of we had clear law on rebates. I'm not entirely sure whether we. I would say that we do. No. Well, okay. Hardly matters. But anyway, so the problem is Intel took us 20 years. We don't have the final outcome yet. Google shopping is going on after 15 years. So it just takes too long. Now, fortunately, we live in a multi-level federal structure, and for example, in the US, when the federal government, as it has under the Chicago School approach, so we've seen all this, under the Chicago School approach, didn't enforce federal competition, antitrust laws as vigorously anymore, we at least had an offset by the enforcement powers of the states, attorney generals, private plaintiffs, etc. In the EU, however, there has always been a tug of war in this respect between member states adopting and enforcing their own national competition laws on the one hand, and a harmonization to a level playing field, which the EU sometimes tried to develop. Now, for a long time, member states had a lot of flexibility in this regard under the Wald-Wilhelm doctrine. But of course, sort of the draft of Regulation 1/2003 tried to harmonize this to a much greater extent. Now, the eventual compromise in Article 3 of Regulation 1/2003 is less categorical than the proposal had been. But nevertheless, for agreed restrictions, there is a near uniformity across the EU. And generally, I don't think there are many problems with this uniformity that is the effect of the convergence rule in Article 3.2. Now, whether it was a very good idea to block exempt narrow MFN clauses and only leave the possibility of using Article 6 or 7 of the vertical block exemption regulation, that may be a matter for debate. But overall, I think the convergence rule in the context of agreements, I think, has worked fairly well. Curiously, however, we do have Article 3.3 of Regulation 1/2003, and so that leaves room for national laws, such as, for example, the French and the Italian laws against narrow MFN clauses and wide MFN clauses in the hotel sector, provided these predominantly pursue an objective different from that pursued by Articles 101 and 102 TFEU, which is, according to Recital 9, the protection of competition on the market. Do these laws pursue a predominantly different purpose? Nobody knows, because, quite frankly, Article 3.3 is shrouded in mystery. Somewhat clearer is the unilateral conduct exception in the second sentence of Article 3 of Regulation 1/2003. It seems clear to me that everything that is not agreed conduct is unilateral conduct, and conduct is agreed whenever there's an agreement, a concerted practice, or a decision by an association of undertakings. If that is not the case, then we are dealing with unilateral conduct. So purely unilateral signaling, conscious parallelism, other tacit collusion, without direct or indirect conduct is all unilateral conduct. And accordingly, member states have addressed this. Greece was free to introduce first a market investigation regime in Article 11, and then more recently in Article 1A, a rule against invitations to collude and price signaling. Germany was free to introduce market investigation regime, so a new competition tool in Section 32F. And at least from the perspective of Regulation 1/2003, Germany was also free to introduce Section 19A of the ARC in the digital sector. Other countries, such as Austria or the Netherlands, are considering introducing a market investigation regime, and who knows, perhaps even the EU will at some point defrost the new competition tool plans. Of course, there's a range of economic dependency rules on the national level as well. Those were the original reason for the introduction of the unilateral exception rule. unilateral conduct rule. And these rules develop. So Germany has introduced an anti-tipping rule in digital markets, etc. But Article 3.2 is not free from discussion. It's, so some dispute the interpretation that I've given that everything that is not agreed conduct is unilateral conduct. So even under Regulation 1/2003, the scope for national experiments is unclear. Now, the scope for national experiments has been further narrowed with the DMA, given that the legislative basis for the DMA is Article 114 of the TFEU. Harmonization is, of course, the main goal, convergence. And accordingly, Article 1.5 of the DMA seeks to preempt further obligations on gatekeepers for the purpose of ensuring contestable and fair markets. Now, curiously, however, Article 1.6 DMA deals with the one category of laws that usually seeks to pursue exactly the goals of contestable and fair markets, namely competition law. The Bundeskartellament's very motto, by the way, is contestable markets, fair competition. So the question, what is to be interpreted as competition law and therefore falls under Article 1.6 instead of 1.5, is not settled. Does it matter whether Section 19A is competition-inspired regulation or regulatory competition? I don't think that from a policy perspective that should make a big difference. What are further obligations in the meaning of Article 1.6b? Is it only conduct not mentioned in Articles 5 to 7, or could it address conduct mentioned there? Overall, unfortunately, recent years have seen a tendency to deprive member states of their capacity for national experiments. Given that we are in an era of profound changes, where the correct approach simply hasn't crystallized yet, this tendency is, I think, very unfortunate. So we should rediscover the merits of experimentation. Once differing approaches have been tested, then we can think about harmonization. But harmonizing on an approach whose effectiveness is untested, or worse, harmonizing on an ineffective solution is not the way to go. We are, after all, united, but we are united in diversity. Okay, thank you.
Great. Thanks a lot, Florian. I was for a second concerned, but we are still good in time. So, Stavros, over to you.
Fantastic. So, thanks a lot, and thanks a lot for the invite. It's a great pleasure to be in such an amazing panel. So bear with me, but I would like to start with a story. So in 1965, Bob Dylan took the stage in the Newport Folk Festival with an electric guitar instead of its familiar acoustic guitar. And the audience's reaction was boos and yelling. This kind of reaction filled the room. And this was a paradoxical choice, because we should stop for a moment and consider, why did an artist who was considered the leading star of the folk music revival rebel against the recipe that made him successful? And it seems to me that this story has some similarities with what the Commission is currently doing. So the Commission, back in 2008, put forward its guidance paper, its more economic approach, and now we see that in the recent case law, in the last 10 years, the guidance paper, the more economic approach, has been accepted and are increasingly being accepted in the case law. So it seems to me that we should pause for a second and ask why the Commission now is considering changing the hit, changing the recipe that made it successful. So, my response to this question is that the Commission, through the knowledge and experience it has gained, as we also hear, and I totally agree here with Inge in that, the experience that it has gained since 2008, it became disenchanted with a more economic approach as an interpretive theory of law. In other words, in my view, the Commission has realized that the more economic approach, despite its merits, reliance on economics, reliance on solid theories of harm, has made the application of law, as we hear, too slow, costly, and ultimately ineffective. The law in action looks less appealing than the law in the books. The case law seems to develop the more economic approach in a very conceptually elegant way, but there are some compelling reasons I hope I speak for the Commission here in the right tone, there are some compelling reasons to be still worried about the future of Article 102. So on this basis, my point is that we can argue that the Commission rethinks the more economic approach because it has realized that it's an inadequate interpretive theory of Article 102. And let me clarify this point. By the term interpretive theory that somehow feels a little bit strange, I refer to attempts to reconstruct the purpose of the law in light of its effects in a way that fits and justifies the case law. So if we consider the more economic approach an interpretive theory, namely a mixture of value judgments, legal reasoning, and economic tools and concepts, then we will see that the fact that then we will see that it should be endorsed as long as it performs well. And what do I mean by this point? Many commentators develop a different narrative. They talk about a struggle between a form-based approach and an effects-based approach. So in the eyes of these kind of commentators, the triumph of the more economic approach in the case law means that we are encountering now the triumph of objective economic knowledge over obsolete and primitive formalistic legal reasoning. So if we buy this narrative, then the Commission's current reappraisal is actually meaning that they are trying to undo all the good, objectively technocratic job that they have done. So, and it has been accepted by the court. So, in other words, if we frame the more economic approach as a technocratic policy statement, effects-based, right, mainstream, in line with mainstream economics, etc., and not as a value-laden interpretive theory, then we end up crystallizing certain strands of the case law, dismissing other strands of the case law as primitive formalism, and also dismissing the Commission's now going electric Bob Dylan turn. So, for this reason, I would like to argue here that it's important to recognize that the more economic approach constitutes an interpretive theory about Article 102. So let me now share two thoughts on how the Commission can be supported in this endeavor. So, in my understanding, for the Commission to succeed in its task, they have to clearly articulate a more compelling interpretive theory. A more compelling compared to what? What is included, the theory that is included in the guidance paper. So the guidance paper and the case law that follows it, see Intel, post-Denmark 1, Unilever, understands competition on the merits as rivalry between equally efficient competitors. So the Commission needs to offer an alternative or an additional understanding of competition, perhaps as protecting meritorious rivalry. This could lead to a new standard, which is also old standard. It's already included in the case law, protecting effective competitive constraints, very much in line with also what the court said in Enel. So such a standard would give emphasis on whether a unilateral behavior is likely to harm effective competitive constraints and lead to a rebuttable presumption in that case. So this arguably could bridge the gap between the as efficient competitor standard or principle, Intel, post-Denmark 1, and the less efficient competitor standard, which is under development, but it's there, fortunately, as per post-Denmark 2. So this would mean that the Commission would have to convince the court that the as efficient competitor principle has some limitations, has some shortcomings, and under certain conditions needs to be complemented by the less efficient competitor standard. And then develop a test along these lines, a test that can deal with the shortcomings, for instance, of the as efficient competitor test, which also need to be clearly articulated, the shortcomings of the as efficient competitor test. Also, focusing on effective competitive constraints means that the Commission can revamp or think further the idea of naked restraints and restrictions by object. What do I mean by that? If a unilateral behavior harms effective competitive constraints or prohibits or marginalizes this kind of rivalry, without any pro-competitive explanation, I don't see why not considering this behavior presumptively unlawful, irrespective of any inquiry on the effects. Two last points. Focusing on effective competitive constraints could also help us revamp and bring to the certain stage exploitative abuses, because excessive pricing or excessive data extraction, could be the byproduct of absence of effective competitive constraints, right? So the case law is underdeveloped in this area, but the Commission has already some decisions that offer a very good template. See, for instance, Aspen commitments. And my last point is that by focusing on effective competitive constraints, the Commission and 102 law, if it is developed along these lines, will be able to incorporate also diversity and resilience concerns. Let me give you an example. The Commission would be able to deduce competition harm from unilateral conduct that reduces innovation diversity. Then the burden of proof will shift to the dominant undertaking to demonstrate countervailing or offsetting efficiencies. Thank you very much. I'll stop here.
Excellent. Thank you for that. And I got to think a lot. And one of the thoughts that came about when Anna was talking was the power to shape discussions. And
have the power to shape discussions.
Exactly. So, and in that sense, I'm going to abuse my power now, and I'm going to, like, instead of what I told you, that I'll give you the chance to talk, I thought we can step a bit outside of the ivory tower and have some more questions from the floor, because I know that there are a couple, and then we can also combine that with questions and comments that you have on each other. So let's start with questions from the floor. Who wants to get a ball rolling? Yes. Do you want to quickly tell us your name?
Yes, thank you. Maria Luisa Stasi. I work for Article and Contain. Thank you very much. I've got a couple of questions, actually. And the first one is for Stavros. I very much like what you say, effective competitive constraints and all, especially this into diversity and plurality, etc. What I wonder is, isn't that closer to the concept of contestability and fairness in the DMA than the pure core, well, not pure, sorry, the core competition thing? Or is this in any forms of way relevant for this kind of conversation? I don't think there is a straight line in between, but just as a curiosity. And then to Anna, when it comes to the power in terms of influence of the discourse, I like this very much as well, and I think there are indications in constitutions when it comes, because I'm thinking about who is the regulator. You said which kind of field of law or framework we're going to use. So the point is also, who is the regulator there? And in a democracy, you know, the media regulators, those that sort of tangentially get into the space, they don't regulate speech. They try to regulate or create the conditions for a variety of speech and voices to be in there. And it's usually about, you know, obligation to the public actor, to the state, not to interfere, to create these conditions, et cetera, et cetera. But here we're talking about private actors, and do we need to stick on this idea that we can't regulate speech in a way? So what's the additional challenge, how we can solve these additional challenges, basically? Thank you.
Great. Great questions. More questions.
Yeah, thank you. I don't come from a competition background from a legal or economic perspective. I come from an economic justice policy background. And I found this all very interesting. And the thoughts going through my head is, don't they take a global political economy perspective on this stuff? Isn't this fiddling while Rome burns? So they were kind of big picture kind of thoughts that were going through my head. Basically, be a bit more ambitious is the conclusion. But looking at the discourse, and there's loads of loaded words within this debate, and one of them's competition. And I think the word, in terms of discourse, is what's probably called a floating signifier, i.e. it's used in many different ways, which is useful to whoever's using it. But I think politically, and within the Commission, it's used in a certain way. And I think that it'd be good to hear, and this is my question, the actual definition of competition from the Commission's perspective. and in their work going forward, if they can articulate that in written form as well.
Great, thank you. Do we get one more question? Yes.
Hello, my name is
3 more
Alberto.
questions, good.
I was wondering if you could please add some color to the thought of having different evidentiary standards tied to infringements of 102. It seems that the majority of legal structures don't have different evidentiary standards to different types of wrongdoing. So I'm just wondering what's the thinking behind this difference.
Could you say who you are, please?
Alberto.
From?
A law firm.
Okay.
Good. No publicity.
It's important.
Yes.
Hi, I'm Todd Davis, PhD student at UCL. My question is for Florian. So I'm a big fan of the idea of regulatory experimentation. And as a big fan, I'm keen to know that it's going to work properly. So my question is, how might this kind of regulatory experimentation that you talk about work within the context of the EU, especially in the face of big multinational global firms and platforms which, you know, kind of have the same product globally? And then also, how would it work in a jurisdictional sense?
Great, thanks. Maybe I'll take one more.
Can I make a question as well? A few points. So I was very interested, and I would like to get your views, all of you, on this. When I was starting, doing competition law in the 1990s, we never used concepts like capitalism, power, equality, democracy. These were the forbidden words in the discussions. And the same I would say during the 2000s.
But we also did not use economics.
In particular during the 2000s, yeah. And I would say, we probably were referring to these concepts in the 90s, 70s, and 80s, right? These were also the times where in sociology, for instance, or in economic discussions, concepts of capitalism, power, etc., were really important. But then, since the 1990s, they disappeared. Now we have, with some exceptions in Europe, we have basically these discussions coming in with the New Brandeis School in the United States. So this is what made basically this discussion come back in Europe, in the competition law field. But of course, we had a lot of discussion about democracy, equality, etc., by a number of European economists and sociologists as well have been working in this in the 2000s. Now, when I read the policy brief of the Commission, you start basically with some discussion about democracy and the broader picture. You don't use the term goals, but I don't think we want to get into this debate about it. But you somehow brought in as well in the discussion these forbidden words. Now what I was wondering is if in the guidelines paper you continue using these forbidden words, or is it just only for the text that introduces the debate and somehow wants to make a connection with the people because we are trying to make markets work for people? Is this type of emphasis on these forbidden words going to be there also in the guidelines? And I think that's quite important. Secondly, is a little bit what Anna has said about power. I think it's very important to think of that not just in the sphere of the market sphere, but actually more generally outside the market sphere as well, because power can be convertible from one sphere to the other. I mean, the other spheres, culture, it can be politics, it can be many different things. And Michael Walzer has a very interesting distinction between monopoly and dominance. Monopoly is when you have a monopoly in one market, you are in one scarce good. Dominance, if you're able to convert that power in different other spheres of justice or spheres of activity. And I think what Anna was mentioning there was basically this form of dominance in the sense of converting power from the economic sphere to other spheres. And as she explained, and this is a lot of work in sociology also about that, is that power, is not really just in the Weberian sense of imposing someone to do something that he doesn't want, but it can also be a very indirect form of changing the agenda, changing the way the other person thinks about what actually they want. So, and I think this is much more difficult to assess in terms of methodologies, metrics, and conceptual frameworks. I wanted to understand if the Commission is also thinking about that and investing about that as well, and I don't think this is a kind of area where industrial organization, economics might provide us a lot of help. Third very quick point is this return to values that Stavros mentioned, and this idea of efficient competition. I think this is new speak. I mean, if you realize the way the court defines what is efficient competition, it's not about efficiency. The court basically has a consumer betterment standard. It's a purely distributive justice standard. They say it is whatever is attractive to consumers. That's it. That's what is efficient. But that's not the economic definition of efficiency. And I think, thank God, they haven't taken that. But again, one might question there, why then only consumers? Why, and this is a little bit the debate today, why, if we really think about the European social contract, think about what is attractive, not just to consumers, but to citizens, right? And that could be the efficient competitor in that sense. Although I think we need to have the word of efficiency here, because it basically doesn't mean what it usually means in economics. And final point about the return of the moral values or moral economy values. Well, I mean, it is the place you provide to the naked restrictions concept, or the by-object restrictions. We don't talk about that. There's a footnote in the policy brief about naked restrictions. There is paragraph 22 that provides some examples without using the word naked restriction. It doesn't appear one time in the priority guidance paper. But then, when you look to the case law, well, you have, apart from the AstraZeneca, apart from the Intel, well, you have Super League. Super League is a by-object restriction. You have Unilever, which, contrary to what was mentioned here, doesn't really say that we apply the efficient competitor principle everywhere, because in paragraph 39, there's a disjunctive or. And they say, well, it can be either you can use mechanisms that are outside, effective, efficient competitor will not use, but then or other methods that are not normal, So it's an or, it's not an and, which means that you might have a different non-effects-based by-object naked restriction category, which we would like to hear more about, and to a certain extent is something that also operates in the context of exploitative abuses. I mean, when you think about the Meta case, this is a by-object exploitative abuse to the extent that if there is an infringement of GDPR by a dominant firm, how can it is prima facie anti-competitive. Now, of course, there's always this possibility that Stavros mentioned not to objectively justify, but how are you going to objectively justify an infringement to the law? I mean, how can you objectively justify that you violated GDPR, or that you are, in your example, you basically did all this waste in the river and therefore violated environmental law standards? How is it possible to justify that? Are we going to accept that to be justified by efficiency? That would be the efficient break of the law. I mean, that would be the dream of Richard Posner, but I'm not sure, that would be the dream of the European social contract person.
Excellent. So I think we have a number of questions here, and I think what Johannes brought nicely together was the debate about words. I linked that back to what do we mean by competition. It just reminded me, and now I'm stepping out of the role of the moderator. We had a training with NGOs and civil society organizations about competition law, and by the end of that training, some of the participants said to us, now we have to go back to our colleagues, and we have to basically tell them that we went to this thing where competition is good and cooperation is bad. It's exactly the opposite to what we usually talk about. So I think sometimes what we mean and how we use words is very important. And I think if we're talking about efficiency, consumer welfare in the competition bubble, it also has kind of different meanings even within the competition bubble. But now I'm going to open the floor.
Start?
Yes.
Because can I take my 3 minutes that was left?
Yes.
Okay.
We have time now.
Yeah, because, okay, very interesting. I'm going to be more ambitious. Yes, yes, I'm trying. With the next research project, I'll be even more ambitious if I get the funding. Okay, let me respond to what Johannes was saying and then come back to what Isa was saying. So you were saying power and capitalism was not hip in the 80s and 90s, and then because of, I'm simplifying what you're saying, and then because of Brandeis, now suddenly it's been hip again, the neo-Brandesians. I think I'm going to zoom out even more. So I think what has been happening, and competition is just competition law, competition institutions, market institutions is just one thing in a much bigger thing that happened. Okay, we have the concept of open societies. Popper started that whole idea. Open societies are based on democracies, rule of law, open science, open knowledge exchange. Your ideas are always open, inclusivity, open markets, open borders. When Popper posed that idea, it wasn't very popular. It was only after, but it became popularized post-World War II in the West first. And then after the fall of, let's say 1989, so the fall of the collapse of the Soviet Union, it became almost globally, no, but I cannot speak to everyone, but it seemed like in the West we thought it was now globally accepted that we would all move to a globalization of economy, an integrated economic system based on markets, based on capitalism, with strong international institutions like the WTO and the IMF and the World Bank and the United Nations governing this system, this global system. This is when, what's his name, Fukuyama wrote his famous book, History, exactly. End of History. It's that timing. And during that, let's call it a consensus, I think nobody spoke about power and about capitalism because it was just accepted. Well, power maybe not, but nobody spoke about it because we were so optimistic. Every country in the world would move to a democratic system. Everything would be based on the rule of law. Something has shifted. And I don't know exactly how to pinpoint when that happened. The neo-Brandesians, I think, is a response, is part of that shift, but I don't think it's the only informant of the discourse that we're having in competition law about broadening of the goals, widening of the values, the European social contract, power structures, discourse, which is also an empty signifier sometimes. So it's, and one of the main drivers of that criticism, of that end of optimism, is, of course, that the market mechanism has also brought us extractive economy and depletion of resources. So it does, and that seems to be the consensus now. Well, not everywhere. For many people, the consensus is this is a problem. The other problem that we are all seeing is also the rise of very big corporate power, the likes of which we have not seen in Europe since a very long time ago. Now, my German history is not that good, but I do know that in Germany, pre-Second World War and the rise of the Nazi Party, it was just this interplay between corporate power and political power that made everything possible. And I think there's a worry that ties back to that as well. So there's several worries, and also we see the rise of populism. So we have democratic systems that are open, but they seem to be collapsing from the inside. We have the market system and the capitalist system, which is open, but it seems to be collapsing because of sustainability concerns, but also because of the rise of big tech. And then we have the open markets, which also seem to be, well, at very least, very much under pressure of being renegotiated. And I think the neo-Brandesians are just an element in that, in this much wider discussion, this slinging back towards a slightly less optimistic view on the world. Okay, thank you. So now Isa's question. Can I see?
No, I started late.
No, but now I'm just this was the end of my presentation. So this whole thing that we are doing with modern bigness sits within this framework of this much, much bigger global political economy discussion, really. So I agree with the lady whose name I did not catch, that that is the context in which we're having these discussions as well. Okay, now Isa's question is much more specific. It's about who's the regulator of the media. Yeah, I don't know. So I'm lucky that I have, so I'm from the Netherlands, and this is important, this is my positionality. The Netherlands is a stable democratic country so far. It has a strong media plurality system of publicly funded broadcasters. This has never been problematized, very difficult to pronounce that word, until now in the coalition negotiations. There is a strong public sphere, and I'm very happy that I have PhD students from other countries in Europe, for example, in Poland, which has a very completely different history also in relation to media plurality and public broadcasters. So this discussion about who then gets to regulate comes up all the time. My point is that if big tech companies now dominate the voices, and it's an if, because the proof here is going to be very difficult, because old media is fading out, it's taken over by social media, which is algorithmically curated, and if we think that that limits the plurality not only of voices, but also the exchange of ideas in an open marketplace of ideas, and if we see that as a negative effect coming from the business models of these corporations, then maybe competition law does have a place in that. I'm never arguing for content, for censorship. That's not what I mean. No. Yes, thank you.
I think there's more to be discussed.
Thank you. Thank you very much for the time, Julian. Yes.
Denny.
Theory, the more economic approach, and it is not the end. It's not the end it's not the end of the history, right? And there I would invite the Commission to be bolder, right? You don't need to lay down, for example, substantive tests in there. These are enforcement, these are priorities, right? You're setting out your priorities for the future in this guidance paper. You do not need to set up substantive tests, I think. And in order to sort of get out of this deadlock where, you realize the effects-based approach has become burdensome, the court is sending mixed signals. It was impossible in 6 to 8 minutes to summarize this rich jurisprudence of the court. It's responding with this, making things worse with this process-oriented review. And I think what we have been seeing, this emphasis from the part of the court that your inquiry needs to be complete and consider all relevant circumstances is clothed in a language of fundamental rights, right? That further perpetuates and this profound doubt of whether a conduct is anti-competitive or not. So how to get out of this deadlock? By being bolder, by setting out the new priorities, not necessarily at this stage substantive tests. And at the end of the day, I think, yes, the courts are there to interpret the law, but the Commission enjoys the primary interpretive authority as a body that is expert, that benefits from superior access to information. There are several comparative institutional advantages here at play. And I think the Commission should sort of, take the steering sort of wheel and change the direction in a more bolder fashion.
Inge, do you want to go now, or do you want to? I can also give you the last word if you want to.
Of course, the bar will ask for substantive tests, right?
Yeah, exactly. I'm happy to go now because I think, to be honest, a lot of topics will also come up in the second session on the European model of a social market economy and how competition law plays in there. But maybe just to say as a start, with regard to the concept of power and power in democracy, one should not forget the origin of the EU competition rules, which very much came from Germany after the war, and ordoliberalism also influenced by the experiences during Nazi times on how disbursements of economic power would also serve democracy. And that is also very much the heart of 102, and 102 is there to keep economic market power in check. That's why we have developed merger control to prevent the overly concentration of markets, at least through mergers and acquisitions. And in that sense, to me, it is not a surprise, but a natural evolution that at times where there are growing concerns about inequality and how that comes and how, or is correlated with market concentration, shareholder value, where there are concerns also about sustainability, it's not a surprise to me that competition policy comes back into focus. And I'm heartened also as an enforcer by the fact that civil society sees the potential in competition policy, in how that delivers on goals that civil society cares about. That being said, I think one must absolutely be prudent not to throw the baby away with the bathing water. And if competition policy becomes social policy, or if competition policy becomes climate policy, we risk achieving nothing at all. And that's why, for me, the focus needs to be so much on preserving the competitive process, which in itself is so important to deliver the competitive, the innovative dynamic, to keep products and services affordable, of good quality. Why the consumer dimension is there. Indeed, citizens are not only consumers, but consumers in particular at times of high inflation and purchasing power problems and inequality are very important. And we should not lose sight of the importance of those deliverables of competition policy in its essence and its core business, what that does for these perspectives. On the effects-based approach, I must say, I did not entirely recognize what I heard from my co-panelist about the guidelines now being the Commission doing away with the effects-based approach because it realized it made a mistake. Absolutely not. You know, we absolutely remain convinced that integrating economics in competition law enforcement is absolutely the right way to do. It's very important. I mean, we are governing the conduct of undertakings in the economy. You know, not to have that area of the law, which is an economic field of the law, influenced by economic thinking, I think that would be not very smart. So what we try to do is to see, can we come to an economics-based or an effects-based approach? Can we learn from economics, but in a way where the enforceability of 102 also remains intact, and enforceability within relevant time frames? And there is again where we come to this point to say, can we, and the link with the DMA is quite interesting, because what we have done with the Digital Markets Act is also on the basis of our competition enforcement, on the basis of a lot of economic evidence on the table, to say, okay, these are the areas, this is the type of conduct for which we can very safely say that if you are a gatekeeper, which means that you have a very powerful position, and you engage in this conduct, the conduct is so likely to be so harmful that we ban it ex ante. So that was an extreme form of taking economic knowledge that we've acquired through enforcement and put that into the law. That's not what we are suggesting to do for 102, but there is some middle ground between starting from scratch for every case to show, as if this were a blank sheet, again, why certain conduct has potential negative effects of competition and is not competition on the merits, may not necessarily be the most effective approach. So that is why we are thinking to say, can we categorize? Can we indeed say, like, these are naked restrictions for which, you know, you come close to a by-object restriction in 101, for which the effects analysis and the evidentiary burden for the Commission to bring a case should not be as high as for conduct, where it very much depends on the concrete circumstances of a case, whether that is a problem or not. Just one example, and then I finish. I mean, take, for example, paying a company in order not to distribute the products or services of a competitor if you are a strongly dominant firm. I don't think you need a lot of economics to see that that has a potential exclusionary effect. I mean, if you do, even as a dominant firm, normal volume-based rebates, you know, that's a different ballgame, and there we need a different type of assessment with a different level of economic analysis. Can I just say one last thing on experimentation. I think we're all in favor, and Johannes from his previous job will testify to this, that in the European competition network, I think cooperation has always, has gradually become more intense, and there is a lot of room there also for experimentation in applying the rules and in interpreting, and then at some point then to harmonize it. But one must also be realistic that it's much more difficult to harmonize 27 jurisdictions have developed their own rule. Everyone who's ever tried to do internal market legislation will testify to this. And sometimes it comes as a high cost. Like in the Digital Markets Act, we took the decision from the beginning to say, let's develop harmonized rules for the entire EU market, because it will be more efficient and beneficial to those European businesses who benefit, for example, from access possibilities which were created, than if you do it differently. So yes, experimentation, but it comes at a cost. And there is a lot of focus nowadays, European Council next week with the Letta report on the value of the internal market, including for citizens, including for sustainability. So you need to weigh those two aspects.
Great. Simon.
3 quick points. I think they're interrelated. The first one really is in response to the comment about fiddling while Rome burns. That was what's inspired the cartoon, which some of you may have seen in my article. And you may see I decided it was time to give it another airing today. No. The point is that we are all in danger of getting lost in the technical aspects of our topic. We need to stand back sometimes and look at the big picture. Second point, closely related to that. I mean, Anna was talking about the fundamentals of what power is. And one thing I've written about quite a bit is not so much, we've also written about power in my article with Michelle, but also in particular thinking about what abuse really is. Again, whilst we doesn't lose sight of our rules and what the court says and so forth, it's always useful to go back to basics and think, is this company dominant? Does this feel like an abuse? It's not a test, it's a sense test. And it also can be operationalized in terms of what you really want to take action against. And thirdly and finally, I welcome Inga's reference to the common sense approach of what evidence do you need to establish something. I say as speaker somebody who studied economics, and who was a great one pushing economics from the 1980s and 90s when people were sort of, well, what's he on about? He's a lawyer. But I do think that we are in danger that sometimes we think nothing can be done unless we have masses of economic evidence. So I really welcome what Inga's saying. And it's not new. We're going back to the fundamentals. The Commission's 2004 guidelines on exemption have some very sensible things to say there. And some of the recent guidelines also help one to say, look, economics is great, but we don't always need it. And when we do need economics, it's sometimes modern economics, behavioral economics, environmental economics, not just the stuff that consultants love sometimes.
Great, thanks. Stavros.
Okay. So, two or three main thoughts. So, first of all, I would like to start with something that Inga mentioned. So, in my view, I totally agree with you. The purpose of the law is protecting effective competition, protecting the competitive process. This is an essentially contested concept. So there could be different understandings of what is vigorous competition or effective competitive process. And we see, and this is the tension that also the court addresses, for instance, A.J. Rantos in his opinion in Enel. There could be different understandings. For instance, we can talk about rivalry or effective competition as rivalry between as efficient rivals, as efficient competitors, and then we can also talk about vigorous competition, which requires also less efficient competitors in order for the process to be sustainable. Because as Danny mentioned also, non-yet efficient competitors can also contribute to consumer betterment. So, and these two different understandings are in tension. And in my view, the more refined economic approach that the Commission is wishing to pitch can reconcile these two. Because the as-efficient competitor standard is not to be thrown out. The problem is that it's under-inclusive. So it can be complemented with standards that incorporate also power concerns that can also be economically informed. This is my first point. The second is, I completely agree, and I don't see how we could disagree with the point of the Commission that there could be different evidentiary standards depending on the category. This is also in the law. So Advocate General Bobek in Budapest Bank talks about the fish. If it smells like a fish and it looks like a fish, maybe it's a fish. So if we have compelling evidence or on the balance of probabilities, a particular type of behavior is unlikely to be a source of pro-competitive gains, for instance, or is likely to be a source of anti-competitive effects, then what is the problem with shifting, saying and shifting the burden of...
saying it without having to produce
exactly.
exactly. Of evidence, to be honest.
Exactly. And in relation to that, my last point to something, many things were raised. I cannot address everything, but one point that Ioannis mentioned about naked restraints and restriction by object. So my point, and I have to rethink, my point about restrictions by object is that the Commission, in my view, can rely on by object abuses, and this presumption, as per the Intel burden shifting architecture, can be rebuttable. But within this category, we can have a smaller category of naked restraints, because the examples you put, I agree, it doesn't make so much sense to have naked restraints that are rebuttable. But this doesn't mean, so...
Yeah, in a different way. Yeah.
Okay, and that's the
Good. Thank you. Florian,
Thank you.
last but not least.
Is it? Does it work? Yeah, okay. Last and least. So first, Inge, I wasn't talking about not using economics. The question is, first, what kind of economics do you use? And where do you use it? Do you use it in the establishment of economically sensible rules, which you then apply without necessarily, delving into the effects? Or do you have a case-by-case effects analysis? And I think you're moving again. The pendulum is swinging back from Intel to a more form-based approach, right? These are well. No. I mean, the thing is, of course, it's it hardly matters whether how you call it, but I think it's just a I think I'm completely with Wouter Wils's paper that he wrote on Intel after the General Court decision. I think it needs to be economically informed, but the rules need to be economically informed, and then the judges can apply it, not necessarily without taking any economics into account, but largely without taking economics into account. It doesn't make sense to, well, anyway, okay. So I think exactly. Yes. I think we're not far apart. No. Maybe in terms of terminology a little bit. To the question, how does experimentation work with large multinationals, and how does that work from a jurisdictional basis, in a jurisdictional sense? Well, I mean, it can work, right? I mean, we've seen the German Facebook case, we've seen French Google cases, etc. So I don't think there is either a big problem with jurisdiction, nor is there a big problem with national competition authorities necessarily dealing with multinationals and GAFAM. But don't get me wrong, I'm not arguing for an uncoordinated chaos, right? I'm not saying everybody should do whatever they like and the DMA is evil. That's not at all my point. My point is we do have fora such as the ECN or on a global level the ICN, which exert some peer pressure on competition authorities to stay in a sensible frame. And what I do find problematic is that there are sometimes arguments for experimentation. There are sometimes arguments for convergence and harmonization. What bothers me is that the criteria that we are using and the reasons why we are using these criteria is not necessarily related to these policy questions at all, right? The reason why we have such a strong focus on convergence and harmonization in the DMA is that Article 114 was the easier path to go down. And then we've got these very strange needs to find the boundaries of rules that are for contestability and fairer markets. Those are competition rules. I mean, this is if you need to define competition, I think it's sort of contestability lies at the very heart of ordoliberalism and probably also the European rules, right? And so we are forced by these artificial criteria into a framework that is very far removed from the questions of, well, should we have a harmonized framework, or should we allow national experimentation? That is what bothers me a little bit. Actually, the current approach might lead to more chaos rather than less, because if Article 102 were really functional, and sorry, but Hoffmann-La Roche is easier to apply than Intel, right? And yes, did we make did we have false positives under Hoffmann-La Roche? Definitely. But I really wonder whether which is the graver error, especially in this field where we are only talking about dominant undertakings. Because everybody else can use their rebate scheme and be happy ever after. Is it such a bad thing if some dominant companies perhaps are not allowed to give some form of rebates, exclusivity rebates that may have some efficiencies somewhere, right? If you look really closely, I think the Hoffmann-La Roche was, even though it was perhaps less sophisticated from an economics perspective, from an effects-based perspective, I think it was the better economics, really, because if you take the administrative costs into account, I think that was the case. And by the way, that was the position of the legal service, I think, when Intel was debated.
Great, thank you. So we had this panel under the broad title Zeitgeist. We talked a bit about history and essentially a pendulum, possibly, of developments in one direction and how things might swing back to what we have seen. But certainly times are changing. We are having a conference here with the strong participation of the civil society, things that we haven't seen so much before, and I think that's very much welcomed. Some things don't change, and one of the things is that we run over, but I tried my best, so let's go and have a break.
Discussions that we had in the context of the DMA, as well as the current discussions in the context of Regulation 2003 and the future of Article 102. So I'm very, very pleased to have these colleagues here. And what I would suggest to do is somehow making first the link a little bit with the previous session. There was an interesting question asked, what is competition? I mean, what we think is competition after all? And I think that's an interesting question. I'm interested in that question because I'm currently finishing a paper on exactly that issue, but taking a sociological perspective. I'm actually looking to how sociologists have thought about competition. And there was a very interesting article by Georg Simmel back in the early 20th century, basically, putting forward the idea of competition being a sort of a contest between two parts for the attention or to provide a benefit to a third part, right? So there was kind of this idea, but cannot really go very far with that in terms of operationally. But I think these questions about what is competition have been asked by many people in the past, not just economists or lawyers, but also sociologists. So the second issue is to think about the concept of effects. Because a lot of discussion we had before was effects approach, but sometimes it's not very clear to what really people think are the effects. In my work, I distinguish between the exclusionary effects, the idea of excluding someone, and the market effects. I mean, what would be the effects on the market of excluding someone? So these are two different types of effects. And when we talk about effects-based analysis, are we talking more about the first thing? And how, if that we talk about the first thing, then how different that is from a form-based analysis? Or are we talking about the second thing? And I think that's quite important in terms of terminologically to understand what is effects. The third issue I would like to ask my colleagues here is if they think there is room, even if you take the effects-based approach, a market effects-based approach, let's put it that way, if there's room for by-object restrictions to competition or by restrictions of competition under Article 102, where we're not going to do an effects analysis, like naked restrictions. And if that's the case, and will these be rebuttable, non-rebuttable, and if there's a they are rebuttable, what type of rebuttable evidence you can use? Because you don't redo the analysis under the effects, so you cannot come and rebut the finding of a naked restriction with the idea that it doesn't produce anti-competitive effects, right? So that's the third point. The fourth point is about the emerging, basically, case law, the national authorities as well. I mean, the national authorities have been a key player in the context of Article 102, national courts as well. And here I would say there are two issues. First is how receptive the national competition authorities and national courts have been to the more economic approach. Have they applied it? Have they resisted to it? And secondly, what have they done in terms of by-object or other types of restrictions in the context of Article 102 or their national equivalents? Are there, okay, they haven't really reacted to the more economic approach, but basically they said, oh, that's pretty tough, and let's try to do by-object cases. And this is a little bit what we have seen in the context of the reform of Article 101. I mean, we have seen that most of the authorities can move to bring by-object kind of cases after, the more economic approach. Do we expect, have we seen the same effect of the last 15 years we have been applying the more economic approach? And final question, but these are just indicative questions, just to launch a debate, but you can actually bring in your own perspective. Is there any cross-fertilization between DMA and Article 102? Not in the way that we have more or less, we all agree, in the sense that the DMA provisions are somehow, some cases that we had in national competition laws or European competition or European cases, and therefore we just crystallize that under these rules. But the other way, can actually the DMA provisions or the possible DMA provision that could be added, because there is this possibility that is offered, the future proofing of the DMA, could that lead to antitrust cases and antitrust decisions, maybe of the less effects-based type of analysis, maybe more of an object-by-object type of analysis? Is this something that we envision happening or not? But of course, as I say, this is a very open, menu. I mean, that's my suggestive menu. You can probably choose some of that. You can probably reject it all. But just to open up a little bit of discussion. So what I would like to do is first to start with Damien. Then we move to Thorsten, who is hopefully still there. And then to Inge, to have the last word from the point of view of the Commission. So Damien, the floor is yours.
Thanks, Yanis. Look, actually Yanis, before, outlining here a number of questions he wants us to address, he asked us one very broad question, which I actually took pretty literally.
Okay, so let's go to the question I asked you.
You ask us, how does Article 102, in the way it is currently implemented or is projected to be implemented, if the Commission moves forward with the reform, respond to the European social contract?
Perfect. And go with this question.
And of course, easy peasy question, it's like something you could write a couple of PhDs on. So, and he gave me 8 minutes, to give you a bit my view. So I'm afraid I'll be, obviously short, but also very, very high level. But just, I'll drop a few ideas, and then, we can have a discussion. Obviously, we can move forward towards, the kind of more concrete questions that you just raised. And I would like to do that by, essentially in three sequence. Talking about, the connection between, competition dominance and the European social contract, connection, disconnection, and reconnection. Okay? So basically, I understand, the notion of European social contract really as the core arrangements binding all member states of the European Union in the pursuit of, the common objectives that are laid down in the treaties, right? And my understanding is also that that arrangement underlying the treaties is essentially that of a liberal democracy combined with a social market economy. I mean, you look at Article 2, Article 3 of the Treaty on the European Union, it's pretty clear. Social market economy is referred to, expressly. And everywhere in the TFEU, everywhere, in many places in the TFEU, you find the reference to the core principle underlying EU economic and monetary policy as being open market economy with free competition favoring an efficient allocation of resources. All right? Now, I think what's important and what's sometimes a bit lost is that this concept of social market economy, I mean, this is not a slogan, it's an actual thing. It has a history, and it's really a model. It's a socio-economic model that, in my understanding, and again at a very, very high level, really aims to integrate, capitalism governed by effective competition and regulation, and a welfare state governed by social policies. And I think the important term is integrate. It really aims to integrate the two. These are not compartmentalized spheres, right? So the market and society are not separate institutions. I think that's one of the main ideas. But that means also that competition as a process is considered a social value worthy of protection in itself, right? I think that's clearly apparent from Article 101, paragraph 3, for example, but also from the case law on Article 102, even very recent case law. And conversely, that competition rules must be applied in a way that is socially desirable to guarantee fair outcomes, and that really does not contradict also other social policies, right? So that also means that competition policy essentially must contribute to achieving some overarching goals. For example, I think one of the main objectives of the social market economy model is the protection of equal opportunity, for example, right? And I think that's also the case when it comes to Article 102. I think that's why essentially dominant firms have in EU law a special responsibility, right? A social responsibility, and they cannot undermine, as the court has said many, many times, the structure of competition or the development of that competition, or distort competition to the detriment of the general public interest by resorting to methods different from those governing competition on the merits, right? I mean, I think that's all, very well known. So there is this inherent connection, I think, at the origin of the European social contract. Now, that social contract and the underpinning social market economy model obviously has been under pressure over time from various corners. It has necessarily had to absorb economic and political shocks, and it's been subject to competing models, to competition from other models, and consequently to various influences. And I think one of the most significant influences of the past maybe 30 years has been a form of autonomization of the market sphere and the social sphere, right? And that is, a form of disconnection, a growing disconnection at least between the two. And I mean, again, at a very, very high level, the way I understand it is that this disconnection has had the consequence of shifting the focus of the protection of competition from the process to the outcome, right? There's been a sort of an evolution whereby competition is no longer viewed as a proxy for efficiency, but it's the other way around, right? Efficiency has been increasingly used as a proxy for, what the competitive process was supposed to achieve. And that evolution from process to outcome has also been accompanied by a shift in, one could call the dominant rationality of competition policy towards, economics, right? And by economics, I mean, neoclassical economics with all its assumptions. And there's been a very powerful push because economic concepts, they're very attractive. They're also very useful in many, many cases to rationalize competitive assessments. But obviously, they're also inherently reductive. They cannot capture the full scope of forces and circumstances driving market outcomes. They necessarily fall short of harnessing the complex reality of market interactions. And they are to a large extent unable to factor in, socially desirable values. And where the problem really lies, I think, and that's probably where we have come, or at least we have come very close to that recently, is when economics is no longer considered as a useful toolbox to rationalize assessments, as very rough proxies for market realities, but as the prevailing normative source of legitimate decision-making principles, right? And by extension also of the valid evidence of the uncompetitive nature or abusive nature of particular practices. Now, I drop a footnote here, no journalist in the room, but obviously when we talk about economics in that context lately, I mean, this is economics distilled by economic consultants and as understood by non-economists, chiefly lawyers, mainly judges, right? So, I think that can be a bit scary. And then, I come to my third point, which is really the way forward to me is really to reconnect competition enforcement with, the European social contract. I mean, because I think in recent years, it's this disconnection between the market and the social spheres, combined with extreme economic and political shocks that have led to various crises that have sort of collided and turned into what is often referred to as a polycrisis. And the most prevalent of those economic shocks that has extremely broad political repercussions, I think it's a question of civilization. In fact, it's the digitization of the economy, and that is of a great part of our society, including social interactions, right? And that has led also, economically, from a market perspective, to the emergence of super dominant entities, players, call them ecosystems, which essentially have powers of private regulators, right? I mean, the terms and conditions they set regulate a vast chunk of economic and social interactions in society today. And that, if that does not give them a special responsibility to ensure that the usage of that power is pro-competitive, I mean, then we can just go home and do something else. So, the consequence of that is that I think there is, it's dual. I mean, there is a need to renew and upgrade the European social contract itself. And I think you see a lot of political actors nowadays advocating that and putting forward agendas for the next commission, for the next election, which are really at their core have as, have the need to renew the European social contract. But also then the need to reconnect competition policy with, that social contract to enable that is competition policy to really serve that contract under obviously reasonable condition of certainty, to enable businesses also to contribute to that common endeavor. And that means also reconnecting competition enforcement with other public policy spheres, and there is case law going in that direction in recent years too. And so just to conclude, I mean, somehow that attempt at reconnecting, I think you could see that a bit as the legacy of Commissioner Vestager. I think over her past, over her tenure, I mean, she has forcefully emphasized, the need to take a political approach to the application of EU competition law. And it's interestingly, when preparing my notes yesterday, I had never fully realized that Jean-Claude Juncker is credited as being the first politician to have used the term polycrisis, as a way to characterize the times that we are living in. And that was just a few months after having, after that letter that he sent to Commissioner Vestager right after her appointment, saying, you need to, to be part of a political team, right? You need to apply competition law not, as an island, but, as an institution embedded into, in fact, the European social contract, right? And when you take a bit of a step back and you remember that speech, competition is not an island. All these speeches about fairness and trust, and you connect that with, the Google shopping case and the DMA, and up until, her speech in Princeton earlier, this week. I mean, I think you have a nice, actually, you could really, you have a nice legacy of really trying, to make that reconnection, to reconnect these two spheres. And I think, Linge, this is for you. I think one of the challenge in the assignment that DG Comp has nowadays, with also the Article 102 guidelines, is to translate that in concrete terms into the guidelines, and make sure that these guidelines enable competition rules and competition authorities to really capture the complex relations and dependence between market actors in the current economy, and enable the pursuit of this renewed European social contract in the future. And I'm happy to contribute to enabling that in the coming month.
Thank you very much, Damien. Without further ado, Thorsten, the floor is yours. Can you hear me?
Many thanks. I hope you can hear me well.
We can hear you well. Thank you.
Since Damien took your question on reconnecting the social contract with competition policy and Article 102 seriously, I have to do that as well, and start by saying what I would consider the basic elements of social contract and legitimate expectations that market actors, citizens, consumers, and institutions have. And I think the basic elements would be to have clear rules, to have the right to be heard in procedures, swift enforcement, and then potential court litigation. And where I see where maybe it's too harsh to say that the link is a bit broken, is the length of procedures. Now, I don't want to rerun what we all discussed, what led to the introduction of the Digital Markets Act, but people have looked recently also into the length of Commission Article 102 proceedings. And I think aside from the guidelines, we really have to talk not only on substance, but about procedure. And if you look into the numbers, since 1992, we had 67 Commission decisions on Article 102. You can clearly see from the number that the number of decisions in adversarial proceedings dropped significantly after the entry into force of Reg 1 2003. In the last 3 years, from 2020 to 2023, you only had one decision per year on Article 102. Before it was 2. Now, the main point that I would take out of the data is if you look into the median duration of Article 102 proceedings. And by duration, I mean from the earliest formal or informal step until the adoption of a decision. What you see is, and I don't want to bore you with numbers, but I found them, to be frank, very impressive. You had in 2004 to 2007, the mean duration was 61 months, and it increased to 88 months in the period from 2016 to 2019. You had 16 decisions out of these 67, where the total duration was more than 6 years. The record was set by Google Search AdSense, which lasted more than 9 years, and Qualcomm, which lasted more than 10 years. Now, I really don't want to bore you with those numbers, but I find the numbers, to be frank, disastrous. And I don't want to blame the Commission people, but it seems to be very much about procedure. Damien has used the polycrisis. I think it was the economist Adam Tooze who introduced that term. And I think in this regard, it's not a crisis that has been inflicted externally, but internally by how the game of enforcement of Article 102 has evolved. So I can see that the new magic word seems to be workable, dynamic and workable, effects-based approach to abuse of dominance. To be frank, I'm not convinced by that. If you want, and if you look into the numbers, I think you need massive change. You really need a rupture with how things have been done before. And if you want to do that, you can't just change the adjective. I understand that the audience is also the European Court of Justice and that you have to reconnect to the case law and the people there. But if you want to change Article 102 enforcement, I think it's not only about changing the adjective, but about the main noun. Now, what could that mean? I mean, the Commission is rightly conducting its exercise. We are very much looking forward to the draft guidelines. We think that one idea could be really to group conduct into different groups, to have a group of naked exclusion conduct where you would not need where you would not need an effects analysis. You could go for a second group with an abbreviated effects analysis, similar to what the US, at least on paper, does with a quick look analysis, and then a category where you would have to do the full analysis. But we really think that the Commission should try to be at the forefront of having rules and trying to fill out those first two categories just to get away from these ultra lengthy procedures. Maybe a final point, if we talk about social contract and if we talk about 102 in a broader context, we would need to take into account merger control. I think the Commission has started to be more vigilant on merger enforcement. I think that's one option to not to run into a situation where you have to clean up things afterwards with a 102 enforcement in leveraging cases. We probably have to also wait and see what the outcome of DMA enforcement will be. Maybe the DMA is really a bit of a laboratory for better 102 enforcement. Maybe people can learn from that. And I think we should also have on the agenda a competition instrument that is not abuse-based. You know that in Germany we introduced such tool. We're advocating for it on the European level. So that would be my take on the bigger picture.
Thank you very much, Thorsten. I know Inge has a hard stop at 5, so Inge, the floor is yours to make the connection. Between these points, at least I'm not asking the connection between social market, social economy, and competition, but the points, yeah. And then do it if you can.
What I was going to do, because like Damien, I prepared a bit some ideas on the basis of your fundamental question, and like Damien, for me, it's precisely the integration between these two elements of the social market economy, which is so important and which is so specific to the European model, and which also so well reflects our values as opposed to those of major trading partners, whether that's communist systems or state capitalist systems or purely capitalist systems without the same levels of high protection when it comes to social and environment that we have here in Europe. And I mean, to me it's almost personal, because my previous job before I became Director for Policy and Strategy in DG Competition, I was head of cabinet of Marianne Thijs, responsible for social and employment in the Commission Juncker. And I launched the social pillar with Commissioner President Juncker at the time and with her. So integrating this is for me almost a personal issue as well. But I must say, this is something that came to me when I made this move. I'm a competition lawyer in my genes. When I made this move to the Cabinet on Employment and Social Affairs, people told me like, oh, you're going from one extreme to the other. And to me, it never came across like that, because in essence, when you think about it, both competition policy and social and employment policy, they are a lot about equal opportunities, a lot about empowering people, whether that's people from an employment and social perspective, people also as consumers, but certainly also businesses, empowering everyone, making up this vibrant economic landscape that we have here in Europe, which is not just very large companies and very successful ones. We have those, and thank God we have them, but also a very vibrant SME landscape. Not vibrant enough startup landscape. We're working on that. But that's something which competition policy and social policy very much have in common in my mind. It's about equality of opportunities, protecting also the weak against the strong. We're talking here about Article 102, sanctioning abuses of companies with a dominant position. That too is something which comes strongly in social and employment conditions. What's, I think, specific about European competition policy is that the member states in signing up to the treaty have also explicitly agreed that they themselves would also be bound by the competition rules, and that they cannot favor their own darlings through distortive state subsidies or monopoly rights, for example. And so that too, protecting, including citizens against the state, if you like, companies against conduct by member states, is part and parcel of competition law. So for me, in essence, competition policy is also about fairness in a broad sense. Third point I wanted to make is, and I think we missed that so far a little bit in the debate, that competition policy does not exist in a vacuum. It's not a single set of legislation. Of course, for economic purposes, you carve that out and you put it in a little thing that you put under the microscope. But in reality, this is one set of rules that interact very closely with other sets of rules. And in this concept of market economy, which is corrected for social reasons and for environmental reasons in Europe, competition law very much has the focus on making markets work, on regulating the economic conduct of companies. By definition, I'm sorry I didn't reply explicitly to your question earlier, what is your concept of competition? One element of it clearly is that it's limited to economic activities. Competition policy only covers economic activities, and it therefore by definition is economic policy. But, and I think that's also an institutional aspect. As DG Competition, we are part of the European Commission, with a college of commissioners, where you have one commissioner for competition and another one for climate and another one for environment and another one for social affairs and another one for consumer protection, and different DGs. And the way we produce our policies is that we, of course, all have our focus, but you also coordinate, and the first thing that you try to avoid is that one policy undermines the other, because then you have an ineffective outcome. So the key for me in making this market economy, which is socially and environmentally corrected, work, is that we develop our policies with our own focus on our own core business, but in a manner which supports the policies of the colleagues. And that concretely, I agree with Damien, we have explicitly been doing very much under Executive Vice President Vestager, and Commission Presidents, I think both Juncker and van der Leyen in the last 10 years. In every policy project that we have been developing, think about the horizontal guidelines, where we reintroduced a new chapter on sustainability that covers both environmental but also social sustainability. If I think about, for example, our merger policy, on how we are very much aware that in particular when we come across markets or products and services that have a very important role in developing sustainability, new technologies, how there we pay extra attention to make sure that those technologies do not, through vertical integration, for example, get developed in the hands of a single company only. That's part of this equality of opportunities, to make sure that the push for innovation is there, but when innovation is taking place, to make sure also that it is not limited to the portfolio of the big companies, but that somehow it remains open also for others. If there is any lesson that we've learned also from digital, is how important that is, that you keep also innovation and incentives for innovations going, not only by major companies, but again also by startups. Am I running out of time? I have one more minute to touch specifically a bit on 102 and abuse, because both you and then also Thorsten raised some comments on that. Exclusionary conduct, and is there room for naked restrictions or by object restrictions, or I think the concepts are slightly different between 101 and 102, but I definitely think that there is, and the court has also recognized that. As we have been discussing in the previous panel, I think there are also categories which are not as strong as being naked restrictions, where you just observe the conduct and that's more or less full stop. And I think it's also always important to look, or at least be open to consider the specific circumstances of the case. I think it is important in many respects to avoid oversimplification. I made the point before that competition policy is only one policy which doesn't exist in a vacuum. I think it is also important, and I think that's still a difference between the old form-based approach and what I would now call a revised effects-based approach, is that there must, I think, always be the openness from the perspective of the enforcer to take the particular context into account in which a certain conduct is being displayed. Speed, Thorsten, indeed, I think that's a very legitimate point of criticism, that the enforcement of Article 102 in exclusionary cases in particular has been too slow. I don't think that the 102 guidelines will be a silver bullet that magically will solve that entirely. I think they can be an important part of it in this domain of antitrust law. But I think we need to reflect more globally also on how we deal with things. One of the elements that slows us down is just the sheer volume of case files at times where we all are digital. You know, companies just produce many more data nowadays in their correspondence and in the documents that they hold than in the old days where everything was paper-based. And that, of course, also affects the time that we need, and we need to adjust to that through different things and instruments. One of the policy initiatives that we are taking now as well is to look at our procedural regulation in antitrust, Regulation 1. You asked a question about the DMA and whether the DMA can inform competition law. I think certainly in terms of procedural aspects there are some ideas. Retention orders. Well, no, but I think in terms of investigative techniques, the retention orders, for example, which may be an alternative to sending out very large requests for information or taking too many documents during dawn raids, the confidentiality rings, there are other elements. But we certainly also need to think about our investigative techniques and how we go about it. So, yeah, I mean, from the very broad, big, conceptual discussions down to the very concrete projects which we have on our table. Maybe just a last comment, where for us it is also important to align well with societal concerns that are entirely legitimate, is in the selection of the cases which we pick up. It might be, you know, a straightforward point, but in the cases that we take on, in the new theories of harm that we develop when it comes to abuse cases, we try to align those very well also with societal concerns, and that can be taking up cases in important consumer goods at times of high inflation and purchasing power, and explaining to consumers why these cases are good to them. The Aspen case was mentioned before. It's a case about 6 important cancer treatments, an exploitative pricing case where we achieved commitments that the company would lower the prices by 70%. I mean, those are cases which are good to explain to consumers what competition policy can do for them. But again, also our abuse cases, including on sustainability. We recently opened a case, Llanos, against the Greek power producer on predatory pricing for electricity, for which there is a concern that may have been increasing barriers to entry for others to bring in more sustainable ways of electricity production. We've had our car emissions cartel, where we sanctioned car manufacturers for delaying the introduction of more renewable emission technologies. On the social front, we are, together with national competition authorities, looking into no-poach agreements, and we've been sending strong signals on that. If there is ever any collusion taking place on wage conditions, collusion between employers, then that's to say, of course, not a social dialogue. Those are cases which we will quite naturally prioritize. So that is an important way as well, I think, to show on how enforcement of competition law and competition policy is in tune and tries to support other policy objectives beyond just making markets work.
One question before you go, because I think you can continue a little bit for a couple of minutes. I will give the floor back again to Damien and to Thorsten, because these are guidelines, so there's not a priority guidance. So, and obviously they will have more effect on than the priority guidance. What is your vision about, once you get the draft out, engaging with the civil society? How you want to organize this? Would be a long consultation process again? What is your vision in terms of how the procedure will be organized? I mean, we integrate more civil society now.
Yes. We absolutely very keen on doing that. We see in general in our consultation processes and public consultation that we more easily reach business circles than civil society organizations. And we pay active attention to that to make sure that the input that we get is as balanced as possible. And that's why I'm so grateful, and I embraced with two hands this opportunity. And by all means, let's repeat it once the draft is out. We know that it's not always easy for organizations in the civil society, that you don't have as much manpower as some of the corporate stakeholders to feed us with comments, but any form that works for you, whether that's oral debate or we're always very eager to listen to you. I think also that it is very important that, with the help of academics, you have your voices heard. Because, by experience, we are bracing that there will be a lot of comments coming. And I think it's important that you make your voice heard at that phase as well. So in terms of timing, we will try to get the text out early summer. We will take into account the fact that it's summer break, by then doing a longer consultation. The aim is, as I said before, that we are ready when the new commission enters into function for the guidelines to be adopted. But we will take the time that's needed to consult. We want to get it right. So quality over timing. Thanks.
Excellent. Thank you very much, Ingrid. And I know you have a pressing obligation, but we will continue the discussion. Of course, a few words from Damien and Thorsten, and then I will invite the next panelists to come to the table.
3 points, and while Inge is exiting, just one, to tackle the timing issue. Let's work in a more integrated way. I think the new regulation 1 should enable national competition authorities and the Commission to actually, have joint investigative teams, right? That actually, enable us together to pursue a particular case, right? Because the Commission is also resource constrained, and I think that's a major, factor that explains, the timing of certain cases. So, I think we should move to a model where, people, at the Belgian NCA can actually work on European cases and vice versa. In a very, very seamless way. So I think that's...
You're both in Brussels, so no cost really.
In particular. Cheers. That was going to be my second point. But no, the first one I wanted to mention is I just wanted to bounce back on the point you said about, the emerging trend at national level, right? And I think, yes, I mean, it is a fact that also, given the limited means we've had, the limited expertise, I mean, I have to tell you, competing with Inger and her team in Brussels to attract talent, is a major problem. Now we're managing, it's getting better. We have more means, and we have actually assembled a really good group of people. But so just to say that, it's been a real challenge to bring 1 or 2 cases over the past 10, 15 years. The Belgian Competition Authority has brought very few of those. And a number of those have actually stumbled across, we have a dual structure, but so the college, which has actually, rejected some of the cases we've brought to it, because it didn't fit into the framework, the box as it's been defined by, the parties and their army of consultants. And what we have been successfully doing is that we have been pursuing some, indeed, by object, 1 or 2 cases, including, disparagement, cases and these kind of things, a bit at the margin. And I'm going to give you a very concrete example. We have currently a wonderful case. Pharmaceutical sector, we have a dominant player, we have a practice, well identified, and we have a harm. And then the whole question is, how do we connect, the dominance, and the harm? How do we establish causality, right? And, if you abstract from the complex set of interactions and dependencies, between the customers and the supplier, and you run a pure as efficient competitors test, we're going to have a hard time. It's a rebate case, essentially, very complex rebate case. We're going to have a hard time. So I actually already anticipate that, it's going to be a, pretty, uphill battle. But if you take, the whole set of, qualitative evidence that you really try to capture the reality of the interactions of the supply and demand considerations, of those customers and all the, also the barriers and the constraints that they faced at the time, instead of trying to reconstruct exposed, what the counterfactual, should have been at the time and should have driven the decision at the time. There's a huge discrepancy there. So this is a beautiful case because I think it's going to wonderfully exemplify, the tension between this sort of reductive economic analytical tools that, we are being presented with and, the broader reality. And then really the last point on DMA, I think what you're going to probably see in the coming years, but not immediately, are mini DMAs at national level. Because clearly, these are ideas popping up a bit everywhere now. Taking Article 5 of the DMA as a template and giving the platformization of the service industry, across the board, at national level with all kinds of local, gatekeepers in all kinds of sectors. I think what you're going to see is that there's no way we're going to run, 9-year cases for 9 or 10 years against, these people. Totally unproductive for everyone. And so I think we're going to probably have to take some shortcuts and, moving towards certain forms of regulatory instruments somehow modeled after Article 5 of the DMA.
I'm conscious of time, but I would give the floor for a couple of minutes to Thorsten for any concluding thoughts from his part.
I think Damien is right in saying that with some behavior on some markets, we can't just deal with abuse of dominance, whether it's Article 102 on the European level or similar provisions on the national level. Let's see whether we are really going to see a rise of national provisions, but for certain digital platform markets, it has become, at least to me, quite clear over the last years that we can't, and even if we would be able to step up abuse of dominance investigations to, let's say, 3, 4, 5 years, shorten them, there would still be a new kind of strategy, a new kind of behavior for platforms that really dominate people's lives. So I think Damien really has a point that there we would have to back up antitrust with legislation. But nonetheless, said that, coming back to the overall Article 102 topic of today, I would say this is still the core instrument, and it's to me it's of utmost importance that the Commission, with the new guidelines, tries to throw around the direction of let's say the last 10 years with the more economic approach and ever more differentiated analysis in different cases to be really able to handle the workload. And my final point, what Inge said on the procedural side, we hear that from the Bundeskartellamt, we hear that from other national competition authorities. In times when lawyers have started to use ChatGPT or similar tools to generate a massive amount of documents, then this is a real challenge for authorities. We are currently thinking in Germany about trying to set limits on that, but I think knowing that this is not talking about the big political picture, but really about practicalities to be able to handle these kind of situations, cut down to a clear-cut rule and theory of harm, and being able to have a clear-cut decision in a time frame of, let's say, 1 to 3 years on a certain conduct. That's, to me, the most practical and important challenge for abuse of dominance law.
Thank you very much, Thorsten. I would like to thank you both. And I would like to ask people from the next panel to join me. And we have Susan as well as Severin online, I still hope. We have them. I just, for people to come to move here, I mean, I really like the idea as an academic of page limits or word limit in terms of submissions, although, I usually don't like that to apply to me, but somehow...
Now we know it.
But somehow, I can see the interest of having that. So I'm not going to take time to introduce each of you because I think we'll even have less interesting time for discussions. But I mean, you can mention your name, of course, and the civil society institution you represent. So I would like to start first by the usual stakeholders in the competition law framework, the consumers. And also to congratulate Augustin for his recent election as well as Director General of BEUC. So Augustin, the floor is yours, and I hope our colleagues are Susan and Severin are online.
Super. Thank you. Thank you very much, Johannes, for the very nice words. And it's great that we're having this conversation with civil society. It's something that we already, for quite some time, we're trying to push. We need to get civil society more involved on competition law issues because of the importance of competition law at the end of the day for our daily lives, to put it bluntly. I like the way that Damian kind of presented his introductory remarks with connection, disconnection, and reconnection. We can make a similar kind of exercise looking at the achievements, the failures, and the way forward. And always trying to end with a positive note. In terms of the achievement, I think that we need to acknowledge that a lot have changed in the last 10 years, or a bit more, 12 years, because of the leadership, of course, of Commissioner Vestager, but also all the work that has been done not only at the European level, but also at national level, including many of you in this room and on the screen. When it comes to 102, I think one of the key achievements is the flexibility that we were able to explore in the system of 102 in relation to the theories of harm, in relation to the relevant evidence, and the broad scopes that are protected under 102. And this is something that the court has consistently found, that at least in Europe, we don't follow the narrow economic welfare standards that we know in the US, but it protects multiple interests. And I quote, the well-being in the European Union, the functioning of the internal market, an effective structure of competition, the well-being of both intermediary and final consumers as their ultimate objective. And if we take the case on the judgment of the General Court in Google Android, the plurality in a democratic society. So that certainly is much more than prices, I would say. And more recently, in the European Football Super League judgment, it is referred to the purpose of Article 102 being to prevent competition from being restricted to the detriment of the public interest, individual undertakings, and consumers. So I'm sorry, but here we have a very, very broad scope to exploit and use. And then we go to the failures, or the disconnections. I think we can group them, at least from our perspective and based on our experience, on three groups. One relates to the extreme slowness of enforcement, the over-reliance on industrial organization economic theory, and the third one is in relation of remedies. When it comes to economics, I think here we need to differentiate, and it's something that Damian already mentioned, it was mentioned previously, between the economics and evidence. And of course, the fact that the regulator had been spam or overspam, the rights of defense of the party have been sometimes even abused, I will say, leading to a situation where enforcement have taken very, very long. It also links to a certain extent to the effectiveness of the remedies. We need to be, I think, honest here, and when it comes to the effectiveness of remedies on several cases on Article 102, we are not yet there. So we can mention the old case like the Microsoft Windows Media Player, but also the two cases where the remedies, at least from our perspective, has been suboptimal, which have led, of course, to learn some lessons, and that is one of the elements that have influenced to the fact that today we have the Digital Markets Act. But then looking at the future, I think there are 4 points that I would like to raise and a bonus, if I have time. In relation to slowness in enforcement, I think this is something that certainly needs to be revised from a procedural point of view, and that's where the points made by Torsten. As regards to the role of economics, this should not be at the expense of relevant evidence. And here we need to look broader. We have been, for example, pushing to have a more prominent role to behavioral economics, for example. Simon mentioned environmental economics, but what about financial analysis? Reviewing statutory accounts, financial reporting, communication to shareholders and investors, publish financial performance and targets. This is very important evidence that should be taken into account as well. In relation to remedies, we will have course, the opportunity to discuss this in greater detail when it comes to the review, upcoming review, potentially, of Regulation 1/2003, regarding, for example, the role of third parties in remedy design. And here there will be an opportunity, for example, to align Article 7 procedures with those of Article 9 in relation of commitments, decisions, and prohibition decisions. And the need, of course, to look more at the role of restorative remedies. Another area where I think we can go a bit further relates to exploitative abuses. I think Inge mentioned the Aspen Pharma case. Certainly something that we very welcome, and we were involved at the national level, but also at the European level. I think we can look more at this type of cases, maybe even looking at green abuses, what happens when a dominant firm breaches environmental legislation to gain an anti-competitive advantage. In a similar way as we have seen, for example, practices abusing patent law in the AstraZeneca case, or data privacy in the Facebook case in Germany. Another point, and the last one, is relates to the lack of focus on victims. I think here is as well important. It mentioned that we need to show to people that competition policy delivers to them. And a way to show it to them is that we are intervening and we are actually delivering to you in relation, for example, to compensation. The question of the problem of not having collective redress for abuse of dominance or competition law across member states, but also thinking about other type of restitution that could be mandated by a competition authority.
Disgorgement, for instance,
yeah, indeed.
Profits.
Exactly. And then the point of prioritization, and I finish with that one. And actually, in the last ICN meeting in Barcelona, it was a very interesting poll amongst enforcers present that were asked what were the top factors that their agency takes into account to select cases. The factor with the lowest score, so the lowest, 8%, was likely effectiveness of the agency's action. Literally fell off my chair. So that was a poll at the ACN. So I think here we also need to reflect in the way we prioritize, cases, in order to, or what are the elements that we take into account in order, as I said before, to deliver to consumers ultimately. Thank you.
Well, thank you very much, Augustin. A lot of points. I took a lot of notes. I would like to pass to the other usual suspects in terms of interaction with the Commission, in terms of stakeholders, traditional ones, the small and medium firms. So, and we have Dimitri here from YSV. So, Dimitri, the floor is yours.
Thank you so much. Thank you for the invitation. I think we had a very interesting, fruitful discussion so far. So, may I introduce myself? I represent the Hellenic Confederation of Professional Craftsmen and Merchants. For brief, we will call it YSV. And it's actually an organization that represents almost all the small and medium-sized firms of the Greek economy. So my intention here is to provide some useful insights of the current position of SMEs in my country, Greece, regarding competition. But I think that this information, these insights have a broader application to other EU countries as well, since according to SBA, almost 99% of all businesses around the EU are small or medium-sized businesses. Now, let's focus on the competition policy, which is our main subject here. In general terms, my organization thinks that maintaining equal terms of competition at the level of both vertical and horizontal markets is of utmost importance. In this respect, we are fully in favor and fully support any legal policy or institutional measures and tools that actually promote competition, such as the case of Article 102 and its revision, which is under discussion. And why we do so? We do so because the firms that we represent tend to operate in more competitive environments, at least compared to bigger firms. And why they operate in more competitive environments? Because small firms, because of their SMEs, because of their very small size and their big population, do not have the ability to acquire or abuse or make any dominant position abuse in the markets they operate. That is something that usually happens from bigger firms. So, however, we should also take into account that any distortions in competition and any inequalities between small and bigger firms are not only a result of a market position abuse, such as the case we discuss here. It's also a result of the structure of certain markets that serve SMEs, markets that provide services and intermediate goods to SMEs. More specifically, we think that there are several distortions in competition from markets such as the banking market, the electricity suppliers, the digital platforms that serve SMEs. Let me give you some 2 or 3 examples, if we have the time to discuss them. First of all, we have the banking sector, the market of money and capital. Since the outbreak of the debt crisis in 2008, SMEs, at least in my country, had limited to zero access to capital, to bank credit. And even those few small firms that actually had access to capital, faced significantly higher interest rates compared to bigger firms. Just to give you an example, small firms who had access to capital during the last 10 years had an interest rate of 4 to 4.5%, while bigger companies had an interest rate of 2 to 2.5%. So this is almost double, and this creates unequal access to capital between small and bigger firms. And this creates inequalities and, of course, lack of competition. The second market that we see that there are some distortions is the market that consists of the online platforms that small businesses use for advertising, selling, and delivering their products. When these platforms initially appeared massively 6 to 7 years ago, the prices and the terms of cooperations with the small enterprises were rather reasonable, we could say. After the pandemic, there was a massive wave of mergers and acquisition between these platforms, so we now have only 4 major platforms operating in Greece. And since that happened, we have a major increase in the prices they charge, in the fees they charge to the businesses they cooperate with. I wanted also to note that bigger companies do not use such platforms. They have their own sources, they have their own websites, their own platforms in order to sell, promote, and deliver their products. And of course, we have many distortions in the cases of suppliers, especially suppliers of electricity, which creates a domino effect in other markets as well. Many studies have showed that the price increases in electricity and other major commodities that took place after the pandemic and also after the war in Ukraine, we're at a much higher level than the initial increase that was caused by the war and the pandemic. As a result, studies have also showed that the profits of many big enterprises in Greece, but also in other EU countries, and I think that Mr. Lianos is aware of that, because that was also a position of the Hellenic Competition Authority. So the profits of big enterprises have increased significantly during this inflationary crisis. I have some other examples of markets that there are distortions, but I don't want to consume any time.
Sure, but you raise interesting issue about these oligopolistic structures that one might obviously go with Article 102 in case they can. Actually, it's interesting. We had never talked now about the collective dominance. I mean, we haven't really heard about that since. I mean, in terms of cases since the early 2000s. So interesting that this is not really in the discussion. I would like to move to Susan Wixforth because she has been dealing with the labor side, and she's from the Austrian Chamber of Labor. I don't know if, Susan, you can hear me.
Yes.
And we can hear you, so the floor is yours.
Thank you very much. Just as a short introduction, I explain how in Austria competition policy works and what is our role, which is a special case in Europe. As the Austrian Federal Chamber of Labor represents 4 million of consumers and workers. And the specificity about us is that we are involved directly in the development of competition law and in its implementation, because we have the right to appeal in antitrust and abuse of market power cases in Austria. And we have the right to propose experts as lay judges in the cartel court and as members to the Austrian Competition Commission. So from this perspective, we can gain concrete experience in competition cases. So you maybe ask why competition policy is important for workers. Well, the general assumption is that competition enhances welfare. But in our times of subsequent crisis, we are confronted with different kinds of market failure, such as interruption of supply chains and market concentration, exploitative and exclusionary practices, artificial market foreclosure and collusive behavior, and these facts are enhanced by artificial intelligence and platform algorithms, which further support this development. So without intervention, we rather assist a welfare-reducing effects, especially when monopsony is not accompanied by responsibility, which was mentioned before. Let me come to Austria. In Austria, this month, we have experienced an inflation rate of 4%. Energy prices might explode again, having an impact on all different supply chains. And moreover, we experience an Austrian price markup by manufacturers of branded goods, leading to market foreclosure in the single market. This complaint of us is pending at the moment before the Commission. So let me come to the instruments to prevent the abuse of market power and our assessment of those. We see two important instruments. One is merger control as ex-ante control. So it ideally prevents the creation of unhealthy market power. Unfortunately, this only works to a very limited extent. On EU level, we have only a handful of decisions which prohibit a merger. At the same time, we observe increasing corporate concentration. A few corporate giants dominate industry worldwide. The second instrument concerns the ex post control, so the control of the abuse of dominant market power. How could market dominance control be strengthened, and what else is needed from a worker's position? As was mentioned before by many previous speakers, we need faster procedures to reduce irreversible developments in the market so as to make the market work for people. And to this end, we have several proposals. We should put a new focus on exploitative practices instead of exclusionary practices, because exploitation has a direct impact on consumers' interests. We should also, in this context, think about collective redress, which was mentioned by Björk. We need institutionalized participation of workers and consumers in these procedures. We need to deal with excessive markups and how to establish if the disparity between prime costs and prices is justified. We need to recast the threshold of market domination. To this end, we propose to introduce a disputable presumption of market dominance static at 30% market share. Let me come to my conclusion. Undisputably, antitrust procedures are important for big picture projects. However, the main challenges remain three, according to our opinion. First, as I mentioned, merger control rarely prevents the emergence of market power. Second, artificial market constriction and unjustified markups are difficult to detect and prove. And third, the breakup of monopsony. So the question how to deal with market power per se, as was mentioned in the first part of our discussion. Therefore, competition control is good, but not enough from our point of view. Therefore, let me conclude with a thought out of the box, maybe a shortcut. In addition to the planned reform of the control of dominant position, we also propose a constant price monitoring to identify abnormally high markups by an independent price monitoring authority. We are discussing this in Austria. Administrative pricing for products where such unjustified markups have been identified as a consequence. Because, as was mentioned before, special power involves special responsibility. With this cheek and bold suggestion, I thank you for your listening, and I'm looking forward to our further discussion. Thank you.
Thank you very much, Susan. Again, you know, on the labor side, Séverine Picard has done work on labor platforms, as far as I understand, so, and on the digital labor interaction. So, Séverine, I hope you can hear me, and the floor is yours.
Hi, I didn't hear you very well, but I think I heard Séverine, so I'm just going to jump in, and please shout if that's not my turn. Hello, good afternoon. Thank you so much for the invitation, and my apologies for not being able to be in presence, but I'll do my best nonetheless. So my name is Séverine. I'm the Director of Progressive Policies, which is a consultancy specialized in labor rights and industrial relations. And we have recently produced a report for the European trade union movement on competition law from a trade union lens. So really this research was about better understanding the impact of competition policies and challenges from a worker point of view. And it was quite a large report, but just for the purpose of my short presentation, I want to focus on the impact of corporate dominance on labor markets. There are 3 points that I want to make, and I think I will repeat some of the points that have already been made. First of all, I want to give you a few examples, a few illustrations to explain in practice how market dominance impacts workers. Secondly, I want to talk about enforcement, and I'm pleased because several of you have already raised it. My main point being that we have a problematic enforcement as far as workers' issues are concerned. And then lastly, I want to broaden the debate a little bit and to talk about the very reason why we have abuse of dominant position, and that's the problem of dominance. So first of all, just to give you a few concrete examples of the type of behaviors that we see on the labor market that are quite problematic, where we have a dominant employer or a few dominant employers, they are in a position to impose terms and conditions on their workforce that will further strengthen their own power over individual workers. And so practices would include in particular wage fixing agreements and non-poaching agreements. We've heard that a couple of times now. So these are the agreements where companies agree with each other not to compete on wages or not to poach workers from each other's. So the idea is really to prevent workers from moving from one job to another in order to look for better working conditions. And this type of practices keep wages down and they prevent job mobility, which ultimately has a detrimental impact on innovation. Another type of abusive practice that we see is the multiplication of non-compete clauses. So this has been a long-standing practice. Very often in employment contract, you will see non-compete clauses, which basically tells you as a worker, you don't have the right to work for an employer in a similar business for a number of months or a number of years. Now, traditionally, these non-compete clauses were found in the case of highly specialized workers, people handling trade secrets, for instance, or confidential business information. But what we have been seeing in the past few years is a multiplication of non-compete clauses for everybody and everyone. I had a conversation with an Irish trade union, for instance, which was explaining to me, a trade unionist who was explaining to me that in the hotels, in a chain of hotels, you have as a standard practice now non-compete clauses in employment contracts. So a cleaning staff who will stop working for one hotel would not be allowed to work for another hotel for several years. And there is no reasonable justification to that non-compete clause, except that the objective is to maintain this vulnerable worker into a further vulnerable position. And then we see really all sorts of practices that are really designed to achieve the same effect. In the case of platform work, for instance, we are seeing a rating algorithm who rates workers, and these algorithms are really designed to discourage those workers from offering similar services on different platforms, even though these are supposed to be self-employed workers and not employees, and therefore enjoy a certain type of freedom. These algorithms are really designed to tie them, to lock them in with a single platform service provider. So this is a non-exhaustive list. There is a series of different practices, and practices are moving and changing depending on the legal enforcement. But the overall objective is really to maintain the workforce in a dependent situation. Now, it is possible under the current legal provisions to address and to target these abusive behaviors, but, and that's my second point, we have a question of problematic enforcement, and also possibly we need to question whether there is sufficient willingness on the part of the competition authorities to champion those cases. Now, we've had some precedents in our reports. For instance, we've looked at a court case in the Netherlands where, I think it was a couple of years ago, the competition authorities investigated a wage fixing agreements between supermarkets. So the supermarkets agree with each other to limit the wage increase to a certain quite low percentage. And that agreement came just after collective agreement negotiations broke down with the trade unions. So clearly there was a very clear intention of controlling the level of wages between those employers. In Portugal, we also believe that the competition authorities are very willing to investigate more the issue of wage fixing and no poaching. So in theory, it's not impossible for trade unions to bring a case, including under union law, to have those type of behaviors investigated. And I've just heard Inge Bernert in the previous panel saying that they would be happy to look at it. So that really is wonderful to hear. But the issue is that there is not much willingness or engagement from the trade unions to engage in the enforcement, because the enforcement is so difficult, because it's a policy area that is very technocratic, extremely technical, and we just don't see any reference to those labor market issues in any of the Commission's documents. I mean, to listen to Inge Bernard every time is a pleasure. We've also heard some speeches from Commissioner Vertegen. But none of it appears to be reflected in the actual consultation documents or proposals from the European Commission. So the policy briefing, for instance, on the Article 102, there is, in the introduction of that document, a very interesting reference to the fact that competition policy can pursue multiple goals because it's based on the principles of the EU treaty. And that's great, but that's not reflected anywhere else in the rest of the document. Where in the document does it say that a trade union can be helped to champion a case against abusive practices in the labor market? So there is an apparent lack of interest, or maybe lack of political will, which is happening in a context where trade unions are, in any case, quite reluctant to engage with competition authorities because of previous experience. Competition law is being seen as a very liberal type of policies, with authorities that have in the past been promoting deregulations and been responsible for the losses of jobs. So if we really want to anchor competition policy into the European social contract, then there really is a need to reflect on how to better democratize the debate and how to make the enforcement a lot more accessible to people outside a narrow circle of experts. And I'm just conclude with a last point. When you look at enforcing or better going after abuses of dominant position, it does feel like you're looking at the problem from a very narrow perspective, because you're dealing with the symptoms rather than dealing with the cause of the illness. Now, one of the previous speakers has mentioned the need to do a cleaner job of merger controls. I think we would need to go one step further. So before you talk about abuse of dominant position, you need to talk about, I'm sorry, I have my daughter here who was extremely bored. Very much, chérie. So it's very important that we do need to look at the question of dominance. Corporate concentration is on the increase, and that is, uncontested. Now, I'm using the word corporate concentration on purpose. I'm very aware that competition experts rely on the notion of market power, which is a very different notion than corporate concentration. And that perhaps is the whole source of the problem, because the reality of multinational enterprises today is that large firms are very rarely about a single line of goods or services. Those multinationals are handling a multitude of different markets, different goods, different services, different type of consumers. But behind this rather wide range of activities, you have a coherent business strategy, a coherent approach to labor relations, a coherent approach to corporate governance, to tax strategy, etc. And I'm going just to finish with this. When we talk about dominance, I think we do need to better understand the reality of corporate power today and to capture it in a more effective manner. That probably is going to involve a significant change in the competition assessment. But again, if you don't deal with dominance properly, I mean, you can go after the abuse of dominance, but it's just not going to tackle the problem. Thank you.
Thank you very much, Severine. Very interesting points. Democratization of the debates. I think this discussion today contributes to that. Democratization of enforcement, I think, is very important in terms of the participation of third-party interveners, also much more open, basically, in small and medium firms, labor, consumers, obviously citizens. And thirdly, this move from market power focus to corporate power and concentration. Very interesting. So we leave outside the market only focus to take a broader lens. Talking about broader lenses, most recently we have a newcomer, like a new stakeholder in the game, in particular after the Facebook case and the Meta case of the courts. And I'm talking about us in our, wearing our hat of data protection kind of subjects. And therefore, this is why we're very happy to have Yanis Kouvakas, who's a senior director of Privacy International, to speak a little bit about his perspective on abuse of dominance and more generally competition policy in the social contract.
Thank you, Ioannis, and thank you very much for the invite. I'll try to be extra brief. I see Isa has created a huge list of points, so...
No, those are my notes of what you say.
Oh, okay. Well, we don't get the opportunity to be in these sort of policy discussions or events very often, maybe because we're not exactly competition law practitioners. Most of us in the fields of digital rights usually come from a human rights background or different legal backgrounds, not necessarily competition law. We had to acquaint ourselves with competition law over the last few years, quite intensively, whether we liked it or not, because a huge part of our work, for example, at Privacy International, which, as you can guess, an organization that mainly deals with defending data privacy across the world, was heavily involved with companies exploiting data, and then a huge avenue that emerged for us to tackle these sort of abuses was the competition law framework through the lens of competition law and potential abuses of the dominance these companies could have in relevant digital markets. So over the last few years, we have kind of expanded our work on that by seeking to intervene successfully so far in a couple of mergers like the Google Fitbit one in 2020 or the Facebook TFEU one at a UK national level in 2021, and most recently the Amazon iRobot one. So what brought us to this point, or what sort of highlighted the relevance or prominence of this, was of course the role of data or the use of data by big tech players or companies holding this dominant position when it comes to online services, which has now become quite unquestionable, which is a good sign compared to previous year where a more traditional approach was followed by regulators and they were more hesitant to sort of adopt these approaches. At least this has changed, both at national level, we see post the Bundeskartellamt Meta ruling, as well at Commission level. And what it has also highlighted at the same time is sort of the connection of the fundamental rights impact this sort of abuses or this sort of exploitation of data might have for consumers in general. And I'm saying this because when considering the question that this second panel was posed to, mainly how the European social contract, or through a lens of a European social contract, we could reinvent or reconsider Article 102 of the treaty. The first thing that came to my mind is a recent example in the form of a case study of the so-called pay or okay Facebook business model, which has been discussed or debated quite a lot recently. And just in a way of a brief introduction to it, this basically has to do with Meta's Facebook, and in this case, following a series of fines or sanctions that most of us are aware of. Now Facebook has introduced, and I think it goes together with Instagram, another social media service, has introduced a sort of fee for users if they don't want their personal data to be used to be served with targeted advertisements. They have the opportunity to pay a fee. I think it's a monthly fee that would totally amount per year to around 250 euros and would cover both Facebook and Instagram services, compared to users being served with targeted advertisements where they could just continue using the service for free, in exchange, however, for their personal data being used to be served with ads. And the reason this example came to my mind right away, outside the traditional sort of competition law framework, is first because there have been several concerns, rightly so, raised when it comes from a data protection law perspective. I doubt whether this is a violation of data law, data protection law, to be honest. It might be an undermining of data protection legislation or regulation, but strictly or per se, and it might again raise issues when it comes to consent or what we mean with freely informed consent, though in the context of the present regulation it might still satisfy it. I think it raises a wider question of equality and a wider moral question that again gives rise to a series of other questions around whether we want an evolution of Article 102 to be able to address this sort of inequality, whether we want competition law to be able to judge these moral dilemmas, and what would it mean for people to be able to pay 250 euros per year not to be served with targeted advertisements, instead of not paying and being served with targeted advertisements. And would it make sense if it was the other way around, or would it still be morally dubious? For example, if people were paid 250 euros per year because their data has served sort of the business purpose of a dominant company in the social media field. How much time do I have? I think I'm going to stop here.
Okay,
Oh.
maybe we've got a couple of minutes.
Oh, okay, yes, just one final point on that, because again, the reason I highlight it so much as a moral question is basically we can compare it with other equivalents. We can compare it to someone buying an airline ticket, whether they could fly first class or they could still fly economy class, pay a little extra for a little more comfort. You can pay, again, Facebook a little bit extra for a little less targeting. But in both cases, you do get to enjoy a service. But in this particular case, when it comes to the Facebook example that I brought up, we are again talking about a company provenly dominant in this specific field of a service, a social media, of an online service of the social media market, let's say, where it has kind of become a necessity, or at least there are such strong network effects where it's not really easy to consider an alternative in this particular case. And at the same time, the sort of, and I think this brings in the morality argument of what kind of rule or what kind of trend this might create when it comes to competition in privacy, or actually the exact opposite, which would result in a race to the bottom. And I think if we were to have Article 102 to address these questions, it would have to look a lot further than efficiency, that concepts of efficiency, innovation, consumer welfare. We would have to look at competition law against the backdrop of the values that underpin the European social contract. So, and I think that would be the way to go. We have seen, I mentioned earlier how we, as originally human rights lawyers, evolved to consider competition perspectives into our work when it comes to data privacy. We have seen how also regulators and the European Commission, most notably, have evolved into considering these perspectives. Perhaps this would be the next way forward in light of the challenges we are facing in the digital economy. Thank you.
Thank you very much, Jan. It's a very interesting points, in particular the human rights one. I mean, so far, human rights have been used as a shield to competition enforcement, the rights of defense, etc. What you're suggesting, we have also done, a few of us in the past, concerning the right to food, for instance, or right to health, was also to use human rights as a sword. And actually, very recently, I've seen a paper, one of the by Kastrup on basically putting forward this idea as well of human rights as a sword, and referring to this past work on human rights and competition. And of course, in your example, I mean, again, you know, this is a dominant firm, so it's kind of an issue, obviously, that might be of interest for Article 102. And the idea is also to have, you know, why, you know, they need to pay. You don't really have also the possibility to be pads. And because, you know, this is consumers that eventually their identity, their network will provide extremely important value. So why, you know, take a one-sided perspective? And of course, you know, the level of the price is also an interesting issue. Exactly. But of course, you know, I'm just talking here hypothetically, not about a specific example of the company you gave, and I'm only my personal type of, you know, capacity, rather than talking about any institution I'm part of. So I'm now going to pass the floor to Maria Luisa Stasi from Chapter 19, and then to Ulrich from the Balance Now. I think particularly Balance Now has put forward this manifesto together with a number of other. Okay, so you tell us more about that, both of you, and of course, what are your perspectives from the civil society about the debate concerning social macroeconomic competition, the role of competition in general? So, Maria Luisa, the floor is yours, and then Mila.
Now sit down to my notes, Dennis. I'll start by thanking you for this invitation, and also by taking 30 seconds to share a very happy feeling, because I think it might be the first event organized by a non-civil society organizer, where civil society might be outnumbering the other stakeholders. Although, admittedly, we need to sort of narrowly interpret the other categories of stakeholders. Otherwise, if we put them together, we're not going to be the majority. But still, very good feeling. So thank you very much for that as well. Very interesting discussions, and I'm going to be brief also because my co-panelists here, they've already simplified massively my job. I was reflecting on your main question, what's the role of competition in the European social contract? In many instances in this past 5 or 6 years are at Article 19 in different declinations, so I've decided to cherry pick and to give a sort of a high-level response, and then to zoom in and go and look at concrete remedies and concrete solutions to make this role effective. So when it comes to the high-level response, it's very much about the competition goals and the competition policy, and how those link with the European social contract. And here, we've been discussing this quite a lot, and especially I appreciated, Agustin, you making a list that I have here about the recent statements, repeated statements, that competition policy is able to pursue multiple goals. Among those, yes, consumer welfare, innovation, but as a free speech advocate, obviously, I'm gonna take the freedom to focus on 3 of them, which are innovation, plurality, and democracy. Well, or innovation, plurality, and fairness, which can also be something that we discuss. Now, the point is, if we consider that those 3 can be among the goals of competition, I think we still have, and there's, as emerged in the discussion today, a definitional problem, or a definitional challenge rather than a problem. So what do we mean by innovation? Innovation can be the process, innovation can be a specific outcome, it can be an incentive to innovate, or it can be an impact on innovation on the market. So to say we need to, as a goal, we have innovation, it tells very, very little. Also, if you go to people that are not lawyers and we say, this is an innovative market, they will look at us and say, what do you mean exactly? What do we expect as market players to do? So I do believe that we have a definitional question to solve there. Same for fairness, although this might have a heavier legal background for the simple reason that fairness is a concept that we find in a number of different frameworks in the European Union. So there we can have a little bit more guidance. And then plurality. I think that there is some case law as well, and one that I like to mention is in Google Android recently. There's been this explicit recognition that the importance of consumer choice is to ensure plurality in a democratic society. So I think it gives a clear idea of what kind of definition of plurality we mean. And in the media sector, in the media environment, this has been a very much a building block of any kind of policy and any kind of legal intervention. So if we do focus, or if you allow me to focus in the next couple of minutes on these 3 goals, the point is then what is the role of Article 102? What we can do concretely. I think one of the things that has emerged today is that we're sort of ready to broaden the attention on different kind of contexts. We've been discussing exclusionary versus exploitative, but it's not only about the category or how we classify them, but exactly what the conducts are. And I think here I want to build on what Severin has already said, which is maybe relying on this difference between corporate concentration and market power, and the fact that we don't need to look only at conducts on a specific market, but also at the structural and systemic behavior. Some people might call it business model, other they will say, it's a systemic behavior that they have. We might use different terms, but the idea is don't look at them in silos. Try to see the links in between these different conducts, these different behaviors, the big picture. And I think there is, apart from what we've said today, which is obviously very, very important and relevant, I think there is an opening to this in a variety of reports that have studied digital markets, that have raised questions about different kind of conducts, variety of authorities, competition authorities, and also regulatory authorities. If you think about the Ofcom study on the cloud market, so it's not only competition authorities, but they're questioning specific business models and conducts.
policy statements we've said, also the case law. I think NL sort of opens the door to, when it elaborates on competition on the merits, it sort of hints to the fact that there are a number of conducts that might not be competition on the merits, so we can focus on those as well. And then on national level, national competition authorities, they've sort of are being a little bit more creative, let's say. Yannis was focusing on we've been discussing the Facebook case in Germany, but also think about the French case about Google abusing its dominant position in the use of material from publishers. So this is one thing. Maybe we can. It's time to broaden the conducts. We've been discussing about by object as well. So for one of them, maybe we are already capable to say to identify this value or the harmful impact, and say we don't need a further analysis. For others, we might need this analysis. The last point I wanted to raise on this specific issue is, and then I'm going to be extremely more concrete now, and going to one specific market or environment, let's say, which is the social media market. So I've noticed a little bit of a trend. The reform of Article 102 is going to cover also tying and bundling as one of the specific categories of conducts. And we have a lot of case law about this and a lot of indications. But what we're seeing increasingly in digital markets is that the companies come in with a fully fledged set of services and products. And those services and products, sometimes they constitute one market, sometimes a lot of different markets, but it's not clear. It's a blurry line. And we're shifting towards this concept of ecosystems. So my point is, if we look carefully, there might be a number of traditional markets that we don't see. Because from the very beginning, ex ante, the services have been put into the ecosystem as a bundle. And so maybe what we can do is, and I think it has a business sense, because the premise is maybe one of these services is highly monetizable, others are more or less monetizable, and others are costs. If you look at the social media environment, hosting content might be monetizable, might not be monetizable. Moderating illegal content is a cost. And recommending content is extremely monetizable, because this is where you get the attention of advertisers, and this is where you make a lot of money. So, but they offer all these services as a bundle. So there might be different markets. I mentioned 3. There might be, well, there are more services, in fact. So the point is, can we, when we assess conducts and we assess harms, can we look at these bundles and say, we need to break them up. We need to create markets where there are no markets. And I'm not advocating for structural remedies. I'm thinking about functional remedies together with obligation to access to the markets. Because if we create structural remedies, so if we go for structural remedies, there will be, in any case, the possibility to come back to the same situation very, very easily. So this is one of the things that could massively help for diversity, for fairness, and for innovation as well. And it might be a very nice immediate consequence that it can help also to protect free speech online. En passant.
Thank you very much. And I think, I was really going to ask before Ingrid left, would we be interested to put something in the guidelines about ecosystems? I mean, I think it's important they put it already in the market definition notice, not in the way I would have liked, but still, some reference to it. In terms of power, I think we need to discuss that. In terms of remedies as well, we need to think about that. Ulrich, the floor is yours. Yeah.
Yeah, thanks again also for the invitation. I think it's great to be here for us as Rebalance Now, which is quite a newcomer to the anti-monopoly field. But personally, I come from a long kind of standing work on corporate power, and I think you mentioned that power would be kind of unwanted term. Formally, I think actually that power is what is at the heart of competition policy.
I was actually in favor of...
I understood that you were not referring your position, but I think from my understanding, and I'm not traditional order liberal, but I think there has been also a history where power has been at the center of competition policy, and I think that's maybe where I'm coming from, and I like very much Anna Gerbrandy's and also Séverine Picard's focus on that we really need to broaden our understanding of corporate power, economic power, because otherwise our analysis also of specific cases might be too narrow. I want to make maybe two general points and then three that are more specific. One, I think when we talk about abuse of dominance, I think we should have in mind that this clearly needs to be based on a broader vision of competition policy. I think Thorsten Käseberg already mentioned that there's kind of a linkage between merger control and abuse of dominance. And maybe that is the opportunity to also introduce what we published this week, this Rebalancing Europe manifesto, which is not our work, but it's a network of NGOs that had published it, and that tries to flesh out a broader kind of agenda, a more ambitious agenda against monopoly power, from having a broader approach about that is not limited to consumer welfare in a narrow sense, but understands the multiple aspects of competition and the impacts on workers as well as democracy or SME sustainability we had also today already. And but then also to develop new tools like a new competition tool. We want to bring that back to the table, but also to better make use of the existing tools, and that is where we can look at the abuse of dominance. And I think just one point that I think to follow up on this relation between merger control and abuse of dominance, I think in times where we have more concentration in the markets, this has an impact on investigations, right? So it's not only about a more economic approach, but it's also about having more concentration we have larger corporations that have more resources to intervene and to shape investigations. So the more concentration you actually have, it's becoming more important to use abuse of dominance cases, but it's becoming also more difficult. And I think we really need to try to avoid processes or concepts that kind of make that interference easier and that increase the likelihood of false negatives. And I think that is, a problem that we have kind of talked about, several people have talked about already today. So we need to really consider the impact of concentrated power on abuse of dominance investigations in the first place. The second general point is that I think, what has also been mentioned today, we need to think about what type of competition we actually have in mind when we talk about abuse of dominance or competition policy in general. And what Isa has mentioned and also others is, first of all, that competition is multidimensional. And that's not only that competition policy might have several goals to keep in mind, but that competition itself can be on quite different dimension. It's not only price, right? And that means, I think, when we have seen a shift in the guidance by the Commission to move away from, at least in parts, from the as efficient competitor principle. I think that's good. I think it could go even further. I think actually, under normal circumstances, efficiency is not, should not be, or competition should not be limited to only efficient competitors. For two reasons. First of all, efficiency or cost structures are simply not independent from economic power, right? If a large company uses its political and economic power to change the labor laws in a country to allow 2 12-hour shifts in a factory, that's obviously increasing its efficiency. You could also say it's exploitative. I don't want to go into the discussion. At least it shouldn't increase the leeway for that company to engage in abusive practices and not being covered by competition policy, right? So efficiency normally is not the right criteria. it's also because if you focus on efficient competition, you limit competition to a very kind of narrow aspect of competition, because companies might deliberately engage or try to compete on other reasons, not on efficiency. And maybe new technologies might not be efficient in the first place or in the first time, but maybe later. So if you only look at efficient competition or as efficient competition, you will narrow down the competitive processes to more or less incremental changes of existing technologies and cost structures, which would be harmful to innovation. So I think we really need to start from a different viewpoint of competition. So that were the two broader aspects. More specific on Article 102, I think what has been mentioned quite a few times today, so I will be brief, is I think we need a more principled approach. And that means that we really need that in the guidelines, the Commission should try to figure out in which kind of categories of cases we don't need individual effects analysis. I think that several speakers have made this case, like Florian Wagner von Papp or Thorsten Käseberg. I think it's really important. I think what has not been talked about that much today is we didn't really talk a lot about remedies, because it's not really directly in the guidance, but nevertheless, I think it's an important aspect. Also, when we look at 1/2003, there should be no priority of behavioral remedies. Because we see the problems, especially in digital markets, to actually monitor and enforce behavioral remedies. There are so many opportunities to kind of use different levers on a platform to avoid, to maybe stop a certain practice, but go for the next one. And I think it's right that the Commission in the Google AdTech case has kind of brought structural remedies on the table. And I think we should go down that road further. And maybe also a second point to remedies would be to think more about interim measures, which is also could be a tool to speed up processes a little bit. And the third thing is it's also beyond this specific guidelines, but it's also related, is exploitative abuses. I think that has also been mentioned a few times. We need more work on that. It's good that there have been some cases, but I think it's becoming more and more important if we think about sustainabilities, but also if we think about global economic structures. I think there's a long shot that is obviously not an easy one, but I think we also need to think about exploitative relationships in global value chains. And if we don't do that, it will also be very harmful for kind of our international standing, our efforts to move to a more equal and peaceful world. I know that it's not a very easy thing to go from maybe a European-based abuse of dominance to a more kind of international approach on global value chains, but I think we should at least try to. I think it's good that, for example, the ICN had a discussion on this in agriculture and food, and I think this should be at least supported, and we should think of how we can support national competition authorities in other countries, how there can be maybe also joint investigations that go beyond Europe. So that is obviously a long shot, but sometimes you also need to have long dreams in a way, long-term dreams. Yeah, thank you.
Well, I wouldn't agree more with you, in particular your emphasis on global value chains. I'm pretty happy that this is now part of the competition law and economics vocabulary. I mean, at the time we have been writing about this many years ago, I think probably 7-8 years ago, I think people were just looking to us strangely, and in particular the focus on the food sector is very, very important as well. So global food value chains is also an interesting issue. I'm not going to make any self-promotion here about this recent book published by Cambridge University Press on the topic. But anyway, we probably take 1 or 2 questions, but I think there will be the possibility to discuss with a glass of wine, probably, another possibility. But if there are any burning questions in terms of issues that you like to hear and have a more public discussion, please, the floor is yours. I'm not disincentivizing you. I mean, if you have any questions, please do them, or any points to make. Yes, Simon. Maybe with the mic. Yeah.
Several people made references to limitation on. A theme has been very much speed of enforcement, or rather the lack of it. And several people made references to ways of controlling that. One of which was to limit the volumes of materials, which seems radical when you're talking to competition authorities, but we do it quite regularly in the court. Certainly it's done in the CAD. So why not the competition authority?
And the DMA also. You have in the DMA as well these page limits.
Yeah, but so if I may, in the court, at least in the Court of Justice of the EU, we have page limits. Yeah. But then you have the annexes. I think good luck with that. I've seen that. I've seen that.
The margins and the TypeScript.
But it's always a matter of rights of defense, etc. as well, I guess. Yeah, it's a balance. All right. Any point? Yeah, Damien? No. Any other point or question? I didn't want to disincentivize you from making questions, really. So, sorry? All right. So, well, let me thank, I don't know, any burning comment from you? Yes, go ahead.
Sorry.
Yeah,
Just
go ahead.
one, because it was really interesting. Yes, it was really interesting, to hear about the need to incorporate human rights frameworks into the conversation. And I think the way is being paved on this. If you look at the Court of Justice of the EU judgment in the Bundeskartellamt case, it's basically saying, look, the GDPR, like can be any other law, is part of the legal context. So we have an investigation, you have the legal and economic context. Well, this is part of the legal context. So I think that there it opens many opportunities for agencies. I would not say to experiment, but I think look to the opportunities that we have there. And the other element that comes into play from the same judgment is the duty of sincere cooperation that we have. So that means that an authority, can perfectly well, pick the phone and talk to an agency that is specialized in that field or in that particular fundamental right that we are talking about. Then the whole question now that decision makers will have is how we can create formal channels of cooperation so an agency can share confidential information in a safety way, in a compliance way, so then you don't have the companies coming after you for sharing data outside the case teams. So I think that here we have a lot of opportunities that can be further explored.
Damien wants to react on that. I don't know if you can give the mic. Yeah.
They resonate with competition authorities. All these topics, most of them, they're really part of the conversations we are having, within the DCN days, or in the broader, let's say, community of enforcers, right? Obviously, they raise a ton of different theoretical and practical issues, but they're really part of the conversation. So, I think, if anything, it should really, further incentivize you to continue bringing forward these ideas and these topics, but I found that the discussion. Thanks a lot for
Yes. So maybe in a way to add to that, because I forgot it initially when I mentioned the manifesto. We will discuss this also on Monday in an event in Brussels. So we also try to set up some discussions here, and I think, I'm not sure if there are any places left, but at least there's a live stream if you're interested to follow that.
So it's very interesting to have these discussions in Brussels, and I would like to thank all the speakers today for a very, very rich discussion, I think. We touched upon many different issues. We took slightly different perspectives on things than the usual discussions we have. The competition law, I would like to agree with Damien that these are issues that we have been discussing among competition authorities and among competition authority heads for a couple of years. And I'm also very happy to say that, when we started this idea of the Inclusive Competition Forum back in 2018-19, one of the reasons we started it was that having some experience working with stakeholders, in particular with the trade movement as well as the green sustainability kind of people. These discussions about competition were there, but not to a certain extent to the center of the attention. It was very difficult to make this connection between these basically stakeholders and the competition authorities. In a way, there was a sort of lack of communication, not the sense of communication, they were meeting, they were discussing, but there was in the sense of meaning, they were not necessarily providing the same similar meaning to words and be able to communicate in depth. And I think what I'm very happy to see today is that this gap, in a way, has to a certain extent been filled. We have a number of stakeholders here today that had extremely interesting and insightful comments about competition law and policy, which shows there's been a lot of work done by stakeholders to invest in the learning of competition law and policy, and of course to develop this new agenda they want to put forward. And I think this is very interesting. It is not something that existed a few years ago. And so it's a good start. And obviously this initiative, as well as the conference on Monday and possibly other initiatives in the future, will develop a little bit more this dialogue and this more inclusive community that we want to establish. So thank you very much again for your participation, and let's have a drink. Thank you.